I got caught in a traffic jam. Uh, the Honorable Justice H.N. Sharma is appointed as an arbitrator. I'm very sorry, my lord. But I am to take a mention, my lord, for listening, but tomorrow, my lord, then better. So the NIT has been issued. Okay, okay. Tomorrow, my lord. NIT, new matter, new matter. I took about 19 million. I got it for the petitioner is out of state. Into the document. Or we have informed the court. 19, 20, and 20. Okay. Mr. TKD. Right, Mr. TK, a general prayer has been made on behalf of Mr. TKD, which has not been objected by Mr. M.U. Ahmed, then counsel for the respondent. Accordingly, this is matter after the vacation. That is your answer. That is your answer. Yes. And item number 10, we had filed an additional affidavit on the 11th. The record may be false.
May this is doctor. So Mr. Petition is item 15 of this. Doctor, the respondent also doesn't have objection. I pray that it come after 2 weeks. Okay.
On the prayer for adjournment made by Mr. Harsh Sharma, appearing for the respondent, which is not objected to by the other side, this is the matter after vacation.
Public. Next, for taking of an admission. Next, 21st. Okay. Please visible. Item number 6, we not specific.
Item number 6.
My colleague on the other side also. Fine.
Okay. Mr. S. Bani, Learned Counsel for the petitioner, submits upon instructions that he will not be pressing this matter. He is not pressing this matter. Mr. DJ Mehdi appears for respondent number 5. While Ms. Yudas appears for he is also government. So government and revenue is different. First off, Mr. P.K. Handik, for number 2, while Mr. P. Handik, appears for respondent number 1. The prayer of the petitioner counsel is allowed. This petition is dismissed from the court. Right.
My pleasure. Mr. Document on item number 20. I have
Yes.
taken consent from the other side.
Yes. For adjournment.
For adjournment.
You are for the petitioner. What is your name?
Teacher.
Mr. P. Chaudhary, then passes for the petitioner, please for adjournment.
I have taken consent from
It
that.
happens that you have taken the consent of the other side. Accordingly, this is not after the case.
After the case. This is the first. The consent of the other side back to item number 25, the supplementary. 35. The order for us to file an affidavit. It's ready, we are sending for betting, doctor. Affidavit is ready, we are sending for betting.
What is this matter?
This is settlement of Mohal matter, your doctor. But there's a court ordered file, directing us to file an affidavit, your doctor. So we have already sent it for betting, your doctor. But taken the consent, doctor.
Mr. Who is for the other side?
Mr. P. Dikshit.
Yes.
You have taken consent.
Right, Mr. R.R. Gogoi. Submit that the affidavit in the position has been sent for betting. Accordingly, this is matter after
25th, your doctor.
it's in.
They are on a date, your doctor.
Then will be all benefits. All those will be motion please.
Any day.
Anyway, let it be. Let us see. Benefits.
Very well, doctor.
Yes.
Take your left side, item number 13 and 14 for adjournment.
What?
13 and 14.
13 and 14.
Kindly, the committee needs to close on
My
on third needs to close.
documents. My population. Yes.
The committee needs 13.
Which item?
Item number 13 and 14.
Yeah, Mr. For
for petitioner.
Have you taken the consent of the other side?
Yes, sir.
Okay, on the prayer made by the petitioner's counsel for a journal which is not objected by the star of it. This is the matter,
On 21st next Thursday.
next Thursday.
Thursday.
Okay.
Hari Hoga.
Please, your lordship, first I beg to mention for existing lordship, W50.
New, old matter.
Yes, lordship, I'm filing in 2022 lordship.
What is the matter about?
Pension is the
Huh?
Pension is the
Pension? Pension, not this bench. Pension is not this bench.
May I please, Your Worship? Your Worship, I pray for listing of the matter for admission, Your Worship, either on Wednesday or on Friday, Your Worship. It's the matter.
When was it last listed?
Your Worship, the matter was last listed on 22nd of April 2024. For admission,
Why such a hurry?
Your Worship, its matter pertains to non-payment of contractual fees.
And when did you finish the contract?
Your Lordship, on India 2022, Your Lordship.
You finished in 22 and you filed a case when in 23?
Your
1 year later you filed a case in the report.
Perhaps, Your Lordship, on that particular specific date, I don't have the specific date, Your Lordship, but
After the case, after the case.
much obliged, Your Lordship.
Yes, Mr.
They have been.
J. Hati Muria, then counsel for the petitioner. Who is the thing is allowed to withdraw the writ petition. Mr. Who is the for the other side? You thus appear for the state response. The parents petition counsel is allowed, the petition is dismissed as required. 29, 29 also safe. 30 also safe.
This case may not only be permitted to approve with the liberty to file a fresh.
Why?
Because my lord annexer was a missed in action.
Are you sure?
Yes, ma'am.
Okay, right. Mr. J. Barbuya, land counsel for the petitioner, pays the appeal allowed to withdraw the writ petition with liberty to file a fresh. Who appears? With you that appears for the, all the respondents. Where of the petition counsel is allowed, this petition has withdrawn, with liberty of speech.
Number 2, 3, 4, and 5 have been mentioned by my colleague for the department leader, saying that there was a massive suppression of facts by us, and that's why the matter has been listed. They're not an academic though, but I said there is no suppression.
No, whatever it is, these are all,
Infractors, ma'am. These are infractors, ma'am.
during lifetime.
Infractors, ma'am.
Huh?
2, 3, 4, and 5 are infractors.
2, 3, 4, 5 are instructions.
Infractors, ma'am. He was
Okay, right. So you see, okay, right. Who is appearing for 2?
I'm
And okay,
There was a case pending in the name of same teacher in Lordship. He has not mentioned it. That is my.
okay, right. Miss Smith,
Yep.
M. David Leonard, counsel for the petitioner. Submit that the writ petition has become in. Mr. P. Sharma appears for the petition department. The writ petition is accordingly dismissed as required. Then item 2. Item 3, Mr. S. Banik. Leonard counsel for the petitioner. Submits that the writ petition has become in. Mr. S. Christoph is P. Sharma appears. Secretary Department, so this is also dismissed as fact. Number 3, number 4,
4.5.
Miss L.P. the Miss MDV. Miss MDV. Then council appears for the petition subject to the petition of the town council, Mr. P. Sharma appears for the fisheries department. That's the same thing, okay? Then item 5. Okay, Mr. P. Pathak appears for point number 5, so Mr. P. Sharma appears for point number, for the fishery department. Ms. Q. Das appears for point number. Then item 5, you write, Mr. S. Banik, then counsel for the petitioner, submit the petition as the subject. Ms.
That may be for
M. Devi appears for point number,
private respondent.
or the private respondent. While Ms. Q. Das appears for respondent number 3. It's also a subject, huh? So only one left.
The first one.
Here, Lordship, we have already initiated tender process, Lordship. We have already instructed the Lordship. Actually, what had happened, Lordship?
Yes.
Okay, in the order, original order 2019, actually the matter was remanded back to us. It was not, Lordship, can we go to page number 19, Lordship? Okay. I have page number 19, Lordship. I'm reading it, Lordship.
Yes, page number 19, yes.
See that it may be since the interim order dated so and so passed in WPC has been vacated by order 21/9/2009 passed in IN civil and arising out of WPC so and considering the submission made by Ms. Bhagasai that government has already taken a decision to float NIT and an early death for regular settlement of the I am of the view that instead of entertaining this petition, the entire matter should be remanded back to the government to take a fresh decision both on the point of issuance of fresh NIT and also on the question as to the two parties that are petitioner and the referendum should be allowed to operate the fishery on daily basis pending finalization of NIT. So the decision was to remand it back to us. So we have taken a fishery petition in the so in 2019 we have taken so rightly or wrongly noted
We have taken a
decision that it should be given. It was in which is not court order, Lord. It was our decision that they should operate till finalization of the tender process. Lordship, I don't think, Lordship, this can be read as a court order, Lord. It will not cover under that notification. This inequity is settling in the court order.
Let us see your decision.
So one line after that, can you read me?
Yes, one line after that.
Yes, whatever be the decision, the same be communicated to the, no, prior to that. The writ petitioner should be allowed to operate the fishery on daily basis pending finalization of NAT.
That is to be
That is-
decided.
Therefore, thereafter they should be order 24/12/19, allowing us to operate the fishery.
Where are you reading?
May I read again?
Okay, may I read it? Two
Be that as it may, since the interim order.
Both of you want to read. No,
Oh, that line.
no. You want to read, he wants to read, both of you want to read.
He may read the complete paragraph, that's all.
I'm completely.
No, you have not read the complete paragraph.
That is the reason.
Okay, read
I'm
the
just-
complete paragraph.
Yes, sir. NIT, and I'm reading again, Lord. Decision to float an early date or regular settlement. I am of the view that instead of entertaining this petition, the entire matter should be remanded back to the government to take a fair decision, both on the point of issuance of fresh NIT and also on the question as to whether which of the two parties, that is, writ petitioner or the respondent number 4, should be allowed to operate the fishery on a daily basis, pending finalization of the NIT. Lordship, the court has asked, liberty to take a decision. Court has not opined. Then whatever be the decision, the same may be communicated to the parties as expeditiously as possible, preferably within a period of 10 days from the date of receipt of a certified copy of order. Here, Lordship, I do not think it is a court order. I do not interpret. Lordship, I leave it to Lordship.
Absolutely. After that, the next page at 20. In view of the court's order, they allowed us to operate the fishery. That's
It is administrative decision which will be
last part, 21, it says, the order is issued with approval of competent authority of fishery part and in compliance of the order of the honorable court at its own. So they had to take a call, when to float the NIT.
Yes,
and there will come-
I have given it to us.
So the NIT is going to be issued today, tomorrow.
No, 15, by 15, Lordship, we have instructed.
15th is day after tomorrow. Today is 13th.
Okay.
by 15th of 2020. Till finalization, we may continue that. We'll also participate.
ECS are the right now. ECS already withdrawn the fishery. They can take the fish.
That's it by the fishery.
They can better.
But it was their decision that that those fisheries were under court orders, their operating.
Decision can be reviewed, Lord.
But this is following the court's order.
Administrative decision can, but it is there.
It is following a court's order. That's fine.
Court, but court did not say that. Wait, let us be very clear. What did the court say out?
Two things. Finalize about the NIT, and till finalization, we'll continue. Whichever of the party would continue. But
I am of the view that instead of entertaining this writ petition, the entire matter should be remanded back to the government to take a fixed decision. Both on the point of issuing of fresh NIT and also on the question as to which of the two parties.
and on the second part, they
No.
issued it.
No. They have taken they have reviewed the decision.
In view of the order, 9-4, which we have.
No, your
Let us say
9 for order is based on a court decision.
court decision.
Yours is not based on a court decision.
I leave it. to you.
Yours is based on a
leave it.
court. Yes.
The view which is followed, I leave it. to you.
Yes.
I can just submit.
I know. No, I'm just telling you.
And
I'm just trying to find out more.
what I was on is that Honorable Court said two things. Number one, finalize between A and B and issuance of tender. Until then, the one would continue. We were continuing. You had a right to issue the tender. You did not. Now you are doing very good. Till finalization, we may be allowed to continue. That's all.
Okay, that's right. Mr. P. Sharma, Learned Counsel for the Fishery Department, submit that in terms of the direction passed by this court in file order dated 21/11/2019 in WPC 8467/2019, the entire matter was remanded back to the government to take a fresh decision on two counts. That is, no, firstly, on the question as to whether a fresh NIT, on the question of, firstly, on the question of issuance of a fresh NIT, and secondly, on the question as to which of the two parties, that is, the writ petitioner or the respondent number 4 in WPC 8467/2019. That is Dehing Part 1 Fishery Cooperative Society Limited should be allowed to operate the fishery on a daily basis, can be finalization for the end. That's the end. Mr. P. Sharma sub that the above direction passed by the court in WPC 8467/2010 clearly shows that the decision as to whether the petitioner or Dehing should operate the fishery on a daily basis till finalization of the NIT was left to the discretion of the government. The government thereafter took a decision to allow the petitioner to run the fishery on a daily basis till a fresh NIT was issued. As such, the the letter dated 4/5/2024 issued by the Commissioner Secretary to the Government of Assam Fishery Department would not be attracted to the case of the petitioner. Correct? I have heard the name of I'll complete it later on. This petition is dismissed.
I will also perfect my subject.
It is everything I put. Don't worry. I'm just putting his because yours I've already recorded. I'll just copy paste that.
Today all most of the fisheries.
Huh?
Saying most of all are
Good, healthy, it is healthy. It could be. Ah, Acha, wait, one more thing before that, you're right. Mr. P. Sharma has also submitted letter dated 11/6/2024 issued by the Additional Secretary to the Government of the Assam Fisheries Department, which is to the effect that the District Commissioner Dibrugarh has been requested to ensure completion of the to ensure the publication of the NIT by 15 June 2024 for settlement of the Sesa Nadi fishery and for taking further follow-up action for settlement of the fishery. Then it is right. The letter dated 11/6/2024 issued by the Additional Secretary to the Government of the Assam Fishery Department is made a part of the recorded marking and expected. Miss Yudas appears for point number 3. That is the District Commissioner Fishery Dibrugarh. Yes, any objection, what is your thing? And submits that. The concerned and submits that as point number 3 will take prompt action in terms of the letter dated 11/6/2024 issued by the Additional Secretary to the Government of Assam Fishery Department. That is true.
Made the submission.
Same fishery.
Is it very- But the issue is very. So actually, so far as fisheries in the state, I'm only on Assam. So far as fisheries in the state of Assam concerned, they have to be declared by way of a proclamation under the Assam Land and Revenue Regulation, section 16. Once it is done, the water body becomes a registered government.
Is this the same fishery that you were
No,
that you were
different.
Huh?
No, different. Absolutely.
this fishery you were not operating this fishery.
Which fishery?
This Sesa Nadi.
Chesa was the earlier one which
Yes.
came up.
So isn't this also this
So
not the
that is
issue?
the thing. Fishery would be the same.
So now you are saying that
No, I'm a different count altogether.
different issues altogether.
Different issue, totally different issue. In this case, I'm supporting Bengal.
Okay.
But this would have some bearing. Fisheries in the state of Assam are declared by way of proclamation by under the Assam Land and Revenue Regulation, section 16.
Give me that
I agree with it.
other two matters are almost similar or it can be taken together. You know,
Yes.
My lord, once under 16, by way of a proclamation, a fishery is declared, then it is entered into the respective register maintained at the district level or sub-divisional level, and those volumes are also indicated. Now, it is categorized into either a 60% fishery category or a 40% category fishery, meaning thereby it has largely to depend upon the size and the participation. In a 40% category fishery, an individual actual fisherman can also bid, whereas in a 60% category fishery, he cannot bid. Then there are other factors also, let us then name. But this is how the fisheries are declared and are given by way of settlement. Earlier, it was by auction. After the amendment, it is by way of tender process. Tender process now comes the concept of actual fishery. In 60% category fishery, and it has a bearing because it can be a registered fishery cooperative society, self-help group, NGO, comprised of 100% actual fishery. This is the mean
In the 60% fishery.
in a 60% category fishery, if you bid. But these belong to the scheduled caste category. That is how the entire thing, and in the Qatar district, erstwhile Qatar, Maimal community, Muttar, the fishing community. Now, after a decision by this honorable court, which will bench matter, the Assam Fisheries Development Corporation, the issue was whether they had the power to settle. Because the fishery rules of 1953 recognized the power to transfer to the
So-
AFDC.
So,
Transfer. Such
Transfer
raised
what?
fisheries,
transfer the
Develop-
power.
there's a power to transfer. Now, if it is transfer,
Transfer power of what? Transfer power to settle the fishery.
no, transfer to transfer the fishery, raise the fishery to AFDC.
Okay,
The
for
question
them,
was whether they have the power to grant settlement or to grant extension. Extension was in the negative, but so far as settlement is concerned, it was recognized, yes, AFDC has the power to grant settlement. Now,
who, under what? Under who?
under separate guidelines to be framed by them. After transfer is a full bench decision. And so they have framed the guidelines. In substance, so far as the state of Assam is concerned, the state government can settle 60% and 40% category under the fishery rules, and the AFDC can settle those fisheries so transferred under the guidelines. It has a sanctity of law.
Whether it be 60 or 40.
In Assam now, apart from fisheries, we have got districts, subdivisions, and we have got 6 scheduled autonomous councils. We also have autonomous councils which are not under 6 scheduled autonomous council. The basic difference between the two, if I may take it, is the power to legislate. And the
No,
source,
how can you have autonomous district councils which are outside the purview of 6 schedule?
absolutely. Those autonomous councils which are under the 6th schedule, section of the Constitution of India, by virtue of paragraph 3A and 3B, they have the power to legislate. And fishery being an entry therein, regardless of it being in list 1, list 2, list 3, or the 7th schedule, these autonomous councils, 6th schedule autonomous council, have the power to legislate. Had it been a 6th schedule autonomous council, Caribbean autonomous council, North Carolina autonomous council, or Bodo Territorial council, we have no issue. But those autonomous councils which have their birth under the Act do not have
Which
power
have their birth
But-
un-
under the Act do not have the power. legislate.
under what act?
So far as this is concerned, missing Autonomous Council Act of 1995.
They do not have the power to legislate.
They do not have the power to legislate. They have their councils, etc. They have executive power. They do not have lawmaking power. Unlike under the Constitution, there is lawmaking power to the 6th schedule Autonomous Council.
So this is the same.
This is
This is going to take some time.
it would not just indicate. If Lordship takes up my petition, paragraph 7, I've detailed it, paragraph 7 of the writ petition.
No, so what do you want basically?
Now, these autonomous councils have, this missing autonomous council has declared and now is going to settle by an NIT 180 fisheries, which is only under the domain of the state government or the AFDC. Now, some of these fisheries already exist
It's under the domain of the,
state government in the fishery department or the AFDC.
when you say state government, does it include the settlement that can be made by the deputy commissioner? Can it,
This is the same.
deputy commissioner can
Tender,
settle?
tender issued by deputy commissioner and settled.
The fisheries rules, Lordship, there is nothing called reform, Lordship. There is nothing called that deputy commissioner can settle it, Lordship.
Or then why are you asking the deputy commissioner to issue tender?
No, that is issuance of tender.
Then?
And they have to forward it to us, Lordship. We are the final authority. They are,
They
they are
forward
just,
every,
like, they are
no,
just,
they're just the post office.
yes, Lord.
So there will be a bifurcation.
Basically,
within-
That's all they do.
No, I don't know.
They are
So
basically
there would
the
be a
post office.
bifurcation. within. So far as 60% category fisheries are concerned, they are settled by the state government. And it is challenged by way of a writ petition in this honorable court. So far as 40% fisheries concerned, they are settled by the deputy commissioner.
Okay.
And that is challenged in the Board of Revenue. And that order is challenged in the High. That is how the process goes. But it's always the circle officers who hand over possession in the respective district. and
That's a different thing.
Act-
Circle officer will hand over even
Possession.
for 60% of.
Absolutely, both. And tender would be issued by deputy commissioner for both. Now, this issuance of tender by the missing autonomous council for settlement of fisheries is without jurisdiction.
So-
Absolutely.
One thing, they have an area under their jurisdiction. The missing of council.
It's
If
separate.
they have an area within their jurisdiction, What you're saying, trying to say is that those fisheries, that is not under their jurisdiction.
Absolutely.
Lordship, can you?
I may indicate
I'm supporting him, Lordship. Yeah, much more, shorter Lordship. Clause number 81, Lordship. Clause number 81.
79 first.
81, 81, Lordship will be more clear, Lordship.
Okay, yes.
81, Lordship. Nothing in this act shall affect the application of any law, whether made before or after this act, to the council area, unless such law specifically provides for exclusion of council area of such application. Explanation: for the purpose of this section, law includes any enactment, ordinance, regulation, order, bylaw, rule, scheme, modification, or other instrument having. That means, Lordship, if they have to settle the fishery in any area, they have to first amend the fishery rules, because in the fishery rules, in PTCA, it has been amended, Lordship. So here they have to amend the, we from the government, we have to first amend the
Do
fishery.
they have a separate fishery rule?
No, missing.
For that 79. For that 79. Section 79. The government may make rules for providing for any matter which provision of this act is required to be prescribed or to be given by the rules. So even for settlement of fishery, the executive part, it's a state government has to take the call and frame a rule. Okay, so they have no power to settle any fishery or declare any fishery legal. The entire 180 fisheries which settlement is given is without jurisdiction.
But here they do not have the executive power also is being limited, Lordship. Clause number 23(1). They do not have the executive power also without clause number 23, Lordship, those later on, Lordship. Here, Lordship, here. If you want to, suppose that,
Yes, to the period for the missing performance.
So your Lordship, so far as the power is concerned, section 18.
One is,
Missing of council act. No, fine. Sorry, it is a subject to your Lordship. Subjects to be under the control and administration of the general council.
no, which, this missing autonomous council act 1995. And section 18,
Section
section 18 is power and functions.
functions of the general council.
Yes,
That is your Lordship,
notwithstanding anything contained.
Lordship. Notwithstanding anything contained in
Contained in the other law, with any other
general
law or
council
rule.
executive power, Your Lordship, in relation to the council area over the following subject. Entry 11 is the fisheries. Now, Your Lordship, the issue, Your Lordship, is what my friend is portraying, Your Lordship. There are 182 fisheries, Your Lordship. There are, Your Lordship, some fisheries, maybe, Your Lordship, I don't know, Your Lordship, that which may have the boundaries, Your Lordship, have some way conflict with the boundaries of the fisheries settled by the. It is not that all the fisheries are like that, Your Lordship. If Your Lordship, the missing autonomous council has taken a resolution, Your Lordship, and has, as a policy, has been taking, Your Lordship, that those fisheries which falls within the existing boundaries of the
Okay,
AFPC.
so what you're trying to say is, supposing this is the council area.
Your Lordship,
So there is some fisheries right in the middle.
middle there,
They have got no grievance against that.
Lordship.
They have got grievance basically against the boundaries that's out here.
Lord, if it has, then Your Lordship, we are not settling, Your Lordship. That's that. This is
Now, have you been settling fisheries earlier?
yes, Your Lordship. We have been settling fisheries, Your Lordship, earlier also, Your Lordship. But there are conflicts with regard to some of the boundary disputes, Your Lordship, with regard to some of the fisheries settled by the state government as well as the, Your Lordship, AFPC, Your Lordship. There are boundary disputes, Your Lordship, no doubt about that, Your Lordship. In those, Your Lordship, we normally, Your Lordship, what we do, Your Lordship, we withdraw the settlements in those cases, and ultimately the issue regarding settlement of those fisheries are also pending with the government, Your Lordship. Therefore, Your Lordship, in this case, Your Lordship, I will have to take instruction on that. If it falls within the boundary of the fishery of the.
But what he's harping on is goes into the issue as whether you can have any right over any other fishery. That's what he's saying.
Lordship, that they cannot, Your Lordship, unless it is the government fishery or the fishery settled by the AFPC.
All others, your lordship, we can, your lordship, there is no doubt
The
about it.
government fisheries and only those proclaimed,
Yes, yes,
the proclaimed ones will be under the government
under the government and they have to
and
pay.
the unproclaimed ones will be under you.
Yes, and they are correct, your lordship, if that is there, your lordship, we cannot give it.
The
Those-
thin line which borders me is that a fishery in the state of Assam, which includes sixth schedule and non-sixth schedule autonomous council, has to be declared by the government, under a proclamation.
No, but if it is declared,
If it is
Yes.
declared,
Ah.
if it is declared,
Ah.
that fishery, we cannot presuppose that we could not be within a mixing autonomous council area. If a fishery has already been declared by the state government under the Assam Land and Revenue Regulation, and if that fishery happens to fall within an area of the missing autonomous council, certainly the executive council may take up the matter with the state government. Then look here, do we process under the powers of the Act of 1995 to offer settlement? But it would be preposterous to say that fishery is not even declared by the government under a proclamation. Missing autonomous council in a unilateral manner declares a fishery, jumps over the Assam Land and Revenue Regulation.
no. He is basically saying that those fisheries which
no
have
fishery.
not been proclaimed under section 16, not those fisheries and which is within the area, the missing autonomous
It is
council.
only a water body. It's not a fishery.
Whatever,
They cannot settle any water body.
they can call it a fishery. How does it matter?
What we are saying-
It may not be a fishery as
It
you
may
know
not be
under
my
section
song.
860, that's all.
It is the entire
Yes.
state is in same thing.
For their lottery, for any fishery, lottery, they have to get the government approval. Can you go to pay for 23 lots?
Of 23 also.
Section 18 is being limited lot. Section 20. Section 20, cross 23.
Cross 23.
23 lots.
Cross
Internal page 7.
this section.
Yes.
This is an act.
Yes, the Regional Council may, subject to the provisions of this act and rules made thereunder, and subject to the approval of the government, make bylaws to be executable within the council area with respect to all or any of the matters enumerated in section 18, 19, 43, and 44 of the regulation. So 18 is being limited lordship.
And
For
it is
for
a-
applying the section 18, we are, in another case, we are supposed to, in a.
And it is a
section 18,
publication in the
for
Gazette.
applying section 8, they have to take the approval from us. Lord. Without approval, they cannot do.
Not only approved,
They have
a
the
publication in the
approval, they
Gazette.
have the approval, then I have no, I don't have, we don't have any problem. We are not supporting you Lord, in this.
Right now, your lordship, we have a judgment from the honorable court. I don't have it right now.
We don't have, we are
After
not
that,
having approval.
power of your lordship, the missing autonomous council to settle your lordship. That is market, regards, etc.
We are-
That has been after. That,
We are on fishery.
that your lordship, so far as this case is concerned, my prayer will be your lordship. Let me find a detailed affidavit regarding their allegation. And they, if-
Okay, but what about those fisheries? That, you see, but one thing is that, you see, we cannot stop everything. One thing is, the concerned fisheries, which you think that they have usurped. Given this,
In the next step, lordship, they have enforced the AFDC matter, next matter, lordship. And we have category.
So far as the first case is concerned, serial numbers 174 to 177, straight away. Cesar Lordship was dealing with this matter a while earlier.
in those cases,
174 to 177.
174 to 177.
Okay, so these, so you don't want it.
that.
174, 177 is only.
One thing further, Milord. Since all they have to do is by the dawn of tomorrow, they have to get before this honorable court the approval of the state government
Yes.
and its publication in the official gazette. Anything short of that calls for a and blanket stay order.
As of now, your lordship.
Because a blanket stay order.
18
It has to be
is not being given blanket lordship.
No, you see, one thing, Mr. Counsel. This is not a PIS.
It's not a PIL, but I am an actual fisherman. I may be
Yeah.
nobody, Milord.
Ah.
I may not be by the CESA. But if a power is given to a non-state schedule autonomous council to declare
No.
a particular fishery,
Maybe to the effect that, you see, can you apply for settlement of fishery all over the state?
may not be. But the recognition of their jurisdiction to declare and settle.
No.
Is
But-
under issue.
okay, no, but only in so far as it affects your right. It's
Lordship,
only in so far as it affects your right.
That-
So that will protect.
I would address your lordship on that if
Ah.
lordship bears me for a moment,
Ah.
subject to correction. My lord, there is a particular river flowing, path. Let us call it CESA. And the members of my cooperative society reside in the neighborhood of CESA. So these cooperative societies also their members reside, so we can participate. To the extent CESA is being cut into from 174 to 177, my lord, what has fallen is that we may have a say. This is first part. I'm on the other part. Now, if we are on one page at this and not on the other, wherein my lord is otherwise recognizing the right for the moment, although for the moment, that they have a right to settle, it cuts both. Either they have a right or they don't have a right. It is not hinged upon whether I can participate there or not.
No, but you see, the thing is that right now, this is a writ petition. This is not a PIL.
So far as my
So as a, for a writ petition to be maintainable, the writ petitioner has got to show that some right of his is violated.
174, 177.
So 174, 177. For the other aspect, you have to file a PIL most probably. I don't know. I do not know.
It
Just,
could be taken
so
care of here.
we can be taken care of here. But what I cannot pass a stay order in respect of something your rights are not going to be affected.
174 to 177. That's all. That's all. Similarly, other matters are also there, where they are same issue.
But these things, wait, one at a time. One thing I just want to clarify. Yeah. Look, I've got no hesitation in taking up the matter. Will it be, is this a TV matter or what?
I was thinking,
Is it a TV matter?
because ultimately boils down to that. Ultimately boils down to that. But since we are challenging an NIT, upfront it will be a single bench match. We thought about
It's
it.
only your lordship NIT.
NIT is challenged by the jurisdiction of the Missing Autonomous Council,
Yes.
who are the state government
So
and
there's-
AFDC.
because it goes to the question of the law.
What law to is applied?
Yes,
And the
what law is
Constitution
to be
recognizes
applied.
it.
So whether this single bench can decide the matter.
My lord, may stay and refer. If there is no stay and reference, my lord, then stay and refer to consider by the honorable division bench. And that is okay. That's all. So far as those we have approached. Other cases may not be. Those we have approached, they have their neighborhood, they may be stayed and then refer. That's one view.
On what ground do we refer?
I do not know, but it might be this way, that it calls for the interpretation and application of rule, not the law. So the virus is otherwise in the challenge.
Huh?
Got match sorted. Two order sorted by 295 2024 lawsuit. In this case, lawsuit, autonomous control favor. In another case, lawsuit, I have lawsuit two conflicting orders
Of?
of the single bench. Regarding missing autonomous council, in another case, some orders lawsuit there is there.
That fisheries can be settled by them.
No,
I was study for Malvin Mohol, and within during the pendency of my running the Mohol, the Assam Missing Autonomous Council issued a tender, and the two parts of my Mohol was tender. So I can leave.
So the question is whether whether the regulation pass the missing autonomous council from declaring or settlement of fisheries or settling fisheries in terms of the act. No. Now, even if can I say no or yes? That's the question I'm thinking. Because it is a question of interpretation of the rules and things. I can interpret, but
anything short of virus.
proper.
No, if it's on the virus of the act, then
Then
perhaps
it
division,
Ah.
honorable division. But so far as the applicability of the act, on losing
It's only on
Reading down, reading down. I can read down the act.
Yes, sir.
And your
And also cases of misses.
Huh?
Cases of misses. Talking of cases of misses is always there. Lord, something.
what I must suggest your lordship that let me file an affidavit, your lordship. After going through that,
Yes,
your lordship, if your lordship finds it
Okay,
necessary
yes,
to
yes.
refer, then your lordship. So, and in the meantime, they are interested.
But then you see another aspect is with this NIT that you have issued, it might affect a lot of the fisheries. But because right now only 1 or 2% have come. Tomorrow another
I
3,
will
4 may
take
come.
instruction on that also.
Yes. Because you're going to take, a really broad approach to this thing.
Tomorrow, what will happen? There are another missing autonomous, Rabha, Assam Autonomous Council, Theory Autonomous Council, Senja Kothari Autonomous Council, Sonwal Kothari Autonomous Council, all are in the similar footing also. Tomorrow, everybody will do this fellow.
Now, you know, there
They
are
are
some
not the same
reasons.
thing. They are
There
all
are
in the
letters
same
from
thing
the
only.
authority.
Nobody is doing, all other, all other.
There are, you know, letters from the government that you take steps for generating your resources. That's lead to this decision.
So, like I said, you follow section 23 clause.
Lord, I will come up with that.
Application in the official gazette and approval must be there, was 79, when the rule must be there. For, these are legal requirements under the or also basically on executive power has to be government approval as per section 53 law. They cannot apply section 18, they cannot, in letters.
Whether that approval is there or not, you know, so that so I will have to take this.
Okay.
Till then, I believe the entire thing should be stayed with, otherwise, not in
It
part.
should be, but then
Till it, till it.
whether I
Obviously.
should do it.
Or they will proceed with the rest as, but not finalized. Not halting it though, aborting it though. So far as these are concerned, 174 and.
No, but you see, if I say that, tomorrow some other writ petition comes.
Okay.
With regard to
No,
the,
subject to correction, that if someone's rights has been challenged and the date of opening is 17, they have not come now. So they would not have the right which we
That we
have.
cannot
for
take up.
consideration.
Lordship. If anybody is affected by that, they will come, your
They will
lordship will look into it.
That they will-
At present,
At
your lordship may confine it to 3 or and the 4 your lordship. That's my submission. In ADC also,
But
I
it
think
requires to be stated. The entire thing requires to be said until reopening after vacation. Let them come up with an answer. With that. Let them process with the tender.
no, what, let him file an affidavit.
And within, before vacation,
Has to be before working, has to be.
then individual ones may be stayed.
Let's let's give some chance to some other lawyers to file cases.
In the bottom, yes, sorry.
He might be having another 5, 6 cases all ready to be filed tomorrow.
And it is more of 6 located, another matter. So my matter is also bigger matter.
Okay, similar.
Tomorrow 2 matters.
Oh, so that's all right. In that way, so everything will be.
And lawyers. It is always get this law. Mine is 174 to 178 at page 21.
Yes, okay. Heard Mr. Elbani, learned counsel for the petition. To submit that the power to declare any fishery in the state of Assam is vested only upon the government of Assam in terms of Regulation 16 of the Assam Land and Revenue Regulation of 1886.
Declaration under 16, settlement under fishery rules.
What am I saying? Correct. Where I said declaration. I said declaration. In terms of section 16 of the Special Act 1886, hereinafter referred to as the 1886 regulation. However, the Missing Autonomous Council has issued a notice inviting tender, NIT, dated 5/6/2024, declaring and offering to settle 180 fisheries, which include the Tessa Nadi fishery.
Bifurcated.
Okay.
One
The Tessa Nadia fishery. Wait.
in parts.
Wait, wait, wait.
Page 10, page 9, paragraph 10.
No, where is it? 174 is it?
174 at page 21.
Okay, it doesn't have the name.
No, they have named, they have christened it on their own.
Okay, they've they've given a different name.
The benefit parts are.
Okay,
they've applied
okay.
their own name.
So whatever it is. It includes the various Testa nadi fisheries declared by the state government at serial number 174 to 180 of the NI,
178.
178 of the NI. By renaming the said fishery. Next up. The case of the petitioner is that in terms of section 79 of the Missing Autonomous Council Act, 1995, hereinafter referred to as the 1995 Act. The the government of the state may make rules providing for any matter which matter which
Any particular.
any matter with regard to any provision of this act. And that every rule made under section 79 bracket 1 is to be laid before the state legislature. For approval. He also submits that in terms of section 81 of the 1995 Act, the application of any law, whether made before or after the 1995 Act, shall be effective in the council area, in the missing autonomous council area, unless such law specifically provides for the exclusion of the council area. It submits that though section 18 of the 1995 Act provides for provides that the general council of the MACA, MAC can exercise executive powers in the council area over fisheries, comma, the same has to be done only after rules are made and the same is approved by the government of Assam. In terms of, no, approved by the government of Assam and gazetted, in terms of section 23 of the 1995. That's all. Next, the petition council further submits that while there are regional councils and district councils created under the sixth schedule of the constitution in the state of Assam, the MAC has been created under the provisions of the 1995 Act, and as such would not have the power to make its own law for governance of the MAC area unilaterally. That's it. Right. We also submit that the Sessan Nadi fishery has been settled with the petitioner earlier.
The members of the petitioner society are in a neighborhood of the fishery. So if this is broken up into parts of
Okay.
the settlement, then where do we participate tomorrow in tender?
No, earlier it has been settled with you.
No, earlier we were on daily basis, now.
Okay, okay.
They've withdrawn that.
Okay,
The first
okay,
matter.
okay, okay. He also submits that, the petitioners being in the neighborhood. They being
The members
fishermen,
of the society,
the members of the petition society being
the neighborhood.
in the neighborhood of the Sessan Nadi fishery. Here submits that the members of the petitioner society being in the neighborhood of the Sessan Nadi fishery, which has been renamed and listed in serial number 174 to 178 of the NIT. The rights of the petitioners have been affected as the same is a part of the fishery, is a fishery declared under under regulation 16 of the 1990 of the 1886 regulation by the state of it, by the government of it. Accordingly submits that the NIT, accordingly submits that the MAC does not have the power to settle any fishery unless and until the provisions of section 23 of the 1995 Act
And 79.
and 79 of the 1995 Act are complied. If you notice, are returnable in today's what date?
Today is your lordship,
When can you file?
lordship, the lordship will fix it immediately on reopening your lordship. I will in the meanwhile,
Okay. If you notice returnable in 3 weeks or 3 weeks, Mr. S. Bhattakur. Accept notice on behalf of
3 and 4, your lordship.
3 and 4. While Ms. S.R. Barwa accepts notice on behalf of 5. Who? Mr. P. Sharma accepts notice on behalf of number 6.
1, 2, and 6.
1, 2,
Is also for AFDC.
1, 2. List the matter on
Report 1, there is a common approval.
okay, right. No, let him produce. Why should you produce? Why should you produce? It's his baby.
There I will.
It's his baby, not your baby.
But it is not there, that is.
So let him produce that.
That will be recorded.
And no, where's the question of government approval? There's the question of whether section 23 has been followed or not. Page 23. What do I say? Then we just say, this is the matter on 16th, 16th July. By which date? Mr. S. Bhattakur shall submit an affidavit. He shall also, okay, 18, huh?
Then
He
you
shall,
wrote till 19.
19, okay, 19. He shall also take specific instructions and inform this court as to whether section 23 of the 1995 Act has been complied.
And 70.
And section 23 and 79 of the 1995 Act has been complied. Full stop. Next para. Inasmuch as the petitioners, the members of the petitioner society are living in the neighborhood of the Tessa Nadi fishery, comma, the respondents shall not act upon the NIT dated insofar as serial number 174 to 178 of the NIT is concerned.
I'm deeply.
Also say, well, 34 is the
34, you will
34, I'm not challenging entire standard process. But my lord, I am the settlement holder for 7 years.
Okay.
Yes, my lord. Now, my lord, they have found what
Okay,
proof of-
yeah, it's not completed.
not completed.
When is it going to be completed?
My lord, on my lord, 26, my lord, 2026.
Wait, just a minute. When was it settled with you?
Settled by lord, on my lord, 22/6/2020, 22/8,
22/8.
22/6/2022, my lord. And NIT was issued, my lord.
No, I'm not on NIT. I'm talking about settlement.
Settlement order, my
Period.
lord, is 32, my lord.
Settlement of 21, 20 September 29,
Huh?
2020.
And the settlement or the final settlement was
20
given on 29/2022.
20,
20/9/2022, my lord.
till
And my lord,
7 years.
my lord,
So it will be till 20, so it will be till 19/9/29.
my lord, for 7 years.
And they have given.
Well, we
they
did
have
my-
given around 40 lakhs.
On page 41, my lord, CL number 65 and 66. My lord, safety bill and Borzuli bill, my lord.
Page number
CL number, my lord, 65 and 67.
65, 65 and 66.
Page 41, my.
Okay.
These are just settled by the FDC, but
They are called safety bill. Dotting
safety
and
bill at Doding and Borzuli bill, Min Mahal, 67.
and at the time it was settled, it was known as,
Known as
Bolaji
Bolaji Sampara
Sampara
Min
Min
Mahal, my.
so they've changed his name also.
No, madam. Yes, madam. Please may kindly say page 48, madam. This was later issued by the AFDC for regarding stopping the forcible settlement by the Missing Autonomous Council, page 48.
Where?
My 46 is the letter mail issued by the AFDC to the Secretary Government of Assam Fisheries Department. And my CL number, page 48, my lord.
There.
CL number 1. Bolahi Sampura and next for the safety bill and Doding and Borzuli bill Min Mahal. They are issuing tender by.
Lots of 46, lots of bit clear regarding it.
Page 46, my lord.
Lots of bit clear regarding it.
Regarding forcible 46, may I read, my lord? Regarding forcible settlement of some bill of Assam Fisheries Development Corporation by the Missing Autonomous Council with reference to last matter. Forcible settled by the Missing Autonomous either by the same different name of the bill.
Okay, anyway, right. I heard Mr. S. Bhattakur, learned counsel for the petitioner, who submits that the petitioner has been settled with the Bolahi Sampara Min Mahal
Right.
from a Lakhimpur district for a period of 7 years from 2009/22 till 19/9/29. Full stop. However, by the NIT dated 5/6/2024 issued by the Missing Autonomous Council comma, the said bill has been renamed as
Bill number
Puri Bill at Bilmuk and Borjoli Bill,
Right.
Mean Mahal.
fully no.
No, sorry.
65.
Safety bill at Doding, safety bill, SCP bill at Doding and Puri bill at Bilmuk. At serial number 65 and 66 of the NI.
67, 65 and 67.
Or six- Okay, so it will be safety bill at Doding and Borjoli bill Mean Mahal.
Right.
At serial number 65 and 67
Right.
of the NI. Then you write down all those laws that we put. I'll just write down. No need. No need. But I think we'd have to put down at the end. You see, the petition council submits that when the settlement of the Mahal has been made with the petitioner by the AFDC, comma, the missing autonomous council could not have advertised the said Mahal for settlement. Issue notice, returnable in 4 weeks. Mr. P. Sharma accepts notice on behalf of respondents number. I have for 7.
1, 2, and
1, 2, 3, 1, 2, 3. 1, 2, 3.
7 by Lagat.
1, 2, and 3. 1, 2, and 3. Okay. Mr. S.R. Barwa for 4, 5, and 6. And Mr. P. Bhattakur, S. Bhattakur for point number 7. Mr. S. Bhattakur shall submit that he will file an affidavit within 3 weeks. Then you write, in the interim, the respondents are directed not to act upon serial number 65 and 67 of the NIT. Dated
In respect of safety bill,
5/6/2020. Access is a serial number, that's it.
file of
Okay.
mention
Okay, comma, which pertains,
in respect of
which
original
pertains
bill,
to, which, just a minute,
state with
which pertains to safety bill at Doding and Borjodi bill Mean Mahal.
Similar issues are pending lot. Similar issues.
Pending where?
Here lot. Regarding it, maintaining it, there are 8 cases pending lot.
Okay, so,
I want to check in lot.
okay, list this case. List this case, give me one.
petition number 5753
I have all that.
5753 of
of 2022.
22.
Another,
The other one also, huh? The other one also.
I have 8 methods.
Thank you.
I have 8 methods.
No. Are they all tagged together already?
Already checked.
If they're tagged together,
Not check lot. Want to check in lot.
Okay.
Similar.
okay, anyway, you give this. Give this.
Lord, the input notice, Lord, we have given there, Lord, you will find at page 55.
Yes, in June.
Notice, my Lord, page 55. By which, my Lord, the particular heart is supposed to be settled by the Ram Sabha. Page 55. It is not correct, my Lord. You may kindly see the notice over there. That is only for discussion. In fact, my Lord, the secretary does not have power to settle.
Okay.
This is only for discussion.
Only for discussion.
Premature. Page 36.
That is-
Name of the particular heart is not included.
Maybe, but that does not, that does not receive. One thing I'll tell you. If this hut is going to be settled on that date without call of tender, you come the next date, they ought to give it.
Yes, without call, my lordship kindly see case
No,
36.
but where is the settlement given? No, there's no settlement.
Now, lordship kindly see case 36 is the NIT.
So
In the NIT,
So it doesn't mean that in one NIT everything has to be done. Okay.
this particular NIT has been left out.
No, so what?
Premature.
So you're only speculating that it might happen. You're speculating it might
Last
happen.
year also, my lord, it was settled by the Gram Sabha. This particular act.
You come, I'm telling you right now, no right of yours has been violated. As on today, you're having a suspicion that something will happen without call of tender. That is only an apprehension that you have. It is not a fact.
Now, my lord, we have submitted for various representation to the respondent authorities, praying for include the guard.
So ensure that there is none, it's not settled without call of a tender. That's all.
As per law, man.
That's all. No,
They can settle as per law. That can be.
no, this is premature. This is petition premature.
Yes, yes.
There's no case.
My lord, our lordship kindly see case 30.
There's no case, Mr. Mandal. Sorry.
My lord, case 34, lordship kindly.
34 years.
Case 30.
Yes.
My lord, case 34. With reference to the subject stated above, I have the honor to inform you that the newly patakata will be hard. I pray to request
Then they will decide. Let them decide when is it right.
in the NIT.
You have got no right. Let them decide when the things go. Right. Heard Mr. M.U. Mandal, learned counsel for the petitioner, who submits that the Pataka weekly husk is going to be settled without call of tender, comma, inasmuch as, comma, the tender notice dated 1/6/2024 has not included the Pataka weekly husk for settlement to tender. Full stop. The petitioner's counsel
My lord,
has taken this court to the which page is that? To the
case 36.
to page 55. It has taken this court to the notice dated 6/6/2024 issued by the Secretary Pataka Gaon Panchayat, wherein he has asked members to attend the Gaon Sabha meeting to be held on 13/6/2024 at 11 a.m. to discuss Patakata weekly market, hut and Parakat. That's page 55. The petitioner's counsel submits that as the Gaon Sabha meeting has been called to discuss the Patakata weekly hut, comma, the same would invariably lead to settlement of the Patakata weekly hut with some person without call of tender. Which is call of tender, comma, which is illegal. Mr.
As per law.
S. Datta, learned counsel appearing for the PNRD department submits that the writ petition is premature as the notice dated 6/6/2024 calling for a Gaon Sabha meeting on 13/6/2024 is only with regard to having a discussion on the Patakata weekly hut. And there is nothing therein to show that the market is going to be settled without call of tender. I have heard the counsel for the party. The notice dated 6/6/2024 is reproduced herein below as follows. Page 55. A perusal of the notice shows that the agenda for the meeting includes a discussion to be made in respect of the Patakata weekly hut. There is nothing discernible in the said notice that that the market is going to be settled with a person, comma, bypassing issuance of a notice. Just because the meeting notice is going to discuss the Kata weekly hut and that the tender notice dated 1/6/2024 has not included the said market, does not prove that the said market is going to be settled without call of tender. In view of the above, this court finds that the writ petition is premature. So further, as on date, no right of the petitioner has been violated. As such, this court finds that the petitioner is not an aggrieved person as on date and accordingly does not have the local standard to file the present writ petition. The writ petition is accordingly dismissed.
In fact, my lord, the time of the meeting is today 11 a.m.
11, yeah.
Already one, they may have a better case tomorrow, my lord.
Can it
Huh?
be, can
They
it,
may have a better case after.
Tomorrow you can come.
Yes.
If it is settled, tomorrow you come. Stay order granted.
can it be posted day after tomorrow, my lord?
No,
That we
This
can,
case is premature and without any prayer.
Look, if there's going to be a decision made, but you have to challenge that decision. That'll have to be a separate writ petition. This is a different issue.
liberty maybe.
What liberty? Liberty is always there.
I know, right?
It's a lot. They affect the my lord further.
No. Nothing.
All right. Right below.
So we meet again.
Back to Britain. My parents from the bar want me to go there. So I came back.
Maybe God has some other plans for you. Yes, what is this item?
What do you look? Can you page 28, man?
No, what item is this?
Same, my lord.
Item 7.
7 can I take?
Huh?
7 and same, man. Same cause of action. Now, page 28, you was pending. What are they? 3622.
Yes.
Yes. In public interest, as per decision of the Sunagam municipality, the general public inform that people who are directly or indirectly involved in the business of buying and selling of cow meat products, selling of cow meat such business are completely prohibited in the municipal area from 16 July. As per section 8 of the Preservation Act, till the commencement of the operation of the act enacted by the Government. Now, it is a blanket order, my lord. Our place for our forefathers is running that by the Florida town. Since long, my prior to independence. We are the descendant of those. Now, what municipality can do, my lord? They can go under section 219 or 320. They can remove it if there is a nuisance, if there is a complaint, if there is anything from anywhere, my lord, then they can tap in. Here, nothing, no complaint, nothing at all. Simple blanket order.
What is this section 8?
It's section here was pending. That is clear. After Section 8 of
Yes.
no person shall directly or indirectly sell or hold sale or buy so and so forth, except at the place permitted to so by the competent authority. Competent authority is not appointed. Now they have come up and they say that appointed district. Now they have come with the affidavit saying that district magistrate is authorized as competent authority. Now, subsequently, after that, provided that no such permission shall be granted in such areas or areas which are predominantly inhabited by those so and so, or within a radius of 5 kilometers of any temple, radio station, so and so. My question, one day short point, my lord. whether minister they got jurisdiction to pass the order, blanket order, without any inquiry, no notice, nothing at all. And whether they get jurisdiction, they are not the competent authority. What they can do, my lord, if there is a complaint, they can go, they can inquire into the matter, and then they pass whatever order is declared as per law, they can pass. But here is a blanket order without they can pass. If there is any order, my lord, competent authority is. And since I am running it for since my independence, my lord, prior to independence, my forefather. So as per section 8, my lord, I may be allowed to for this. I'm not saying that, but I am exempted from this position. Lordship, we have filed our affidavit by the executive officer, municipal board, section number 4. In paragraph number 6, Lordship, we have stated they were running their stock without valid license, Lordship. Because so Lordship comes to paragraph 6 of our affidavit in opposition.
Without valid license.
No, yes, you
Because
are
it was
expired.
expired.
No, that's kindly see my page. It is not their page for it. Kindly see page 25. Twenty-four, 25, 26, 25, your lordship, kindly see. License.
Yes.
Your lordship will find page 25, left side, renewed up to 31st March 22. The original one, page 25.
Yes.
Middle portion left side, your lordship will renewed up to. And it is now pending annual fees also by the subsequent. It started from 2020, 14, 2005, 14.
Issued to manager of slaughterhouse.
Yeah.
MD.
Then you was about page 27 also, 26, 27. It is not their case, madam. Notice say that before section 8, it is stopped. Simple. This is their order. It is not their case that there is no license. License is there. It renewed by law up to 22 and it is pending. Yes, that is also pending.
It was up to the date of 31st March 2022, and it was in the name of some Muhammad Abdul Rashid and Muhammad Sheikh Ramzan, but they were expired, Lordship.
Yeah,
But
And
that is
how
not,
they would have to-
but that is not the reason in the order.
that is your answer.
In
Let-
other
let
way
us
also,
see that.
Lordship,
Huh?
now in other way also, Lordship, the competent authority is the district commissioner. So unless and until the district commissioner pass any order in the representation filed by them, they would not allow to run the shop.
Now that
Because
comes
the-
profit point.
Because the competent authority is the district commissioner.
No, you see, forget that. A competent authority, no, forget that. The issue here is you have stopped the 328. Now you have, as per section 8,
Yes.
as per section 8, you have stopped. Which, section 8 is, oh, you have to give reasons for section 8.
Section 8 does not say about the prohibition. It says about the regulation. They can regulate it.
Huh?
They can regulate it. It's not a prohibition. Some conditions are there, my lord. Otherwise, they can regulate. Some special places are there. Yes, we are having places.
But this problem is 5 kilometers from any temple. and all that.
That can say, my.
Huh?
They must say, my lord, that whether there is anything, any temple or anything. Two parts, your lord. First part is, my lord, no person shall directly negative sale of so and so, so and so, so and so, except at the places permitted to do so by the competent authority. Now, so far now we are running, we have been given license to run on a particular place. Fine. Now, because of this act, my the competent authority will see whether this place will remain or some other place is to be given. Only competent authority can see. There, the proviso is there.
So
It is
have
up
you
to
made-
them.
Have you made any representation in this?
Yeah.
Page 30, Lordship.
page 301. Yes. Page 0 to the deputy commissioner and page 32 chairman is municipal. Now this deputy commissioner is the now the company authority. Now. We are ready to comply, madam, whatever is there, madam. We are not saying nothing away of that. Here. Now, how they can pass this order blanket order saying that yes, everything will. No, it cannot. Section 8 does not say about this point. That one order can be passed only by the combating authority, not by the municipal.
Now,
There can pass order only in there if there is a case of nuisance, etc.
now what will be decided by the competent authority that is in the hands of the deputy district commissioner. So already they have filed their representation. So if a direction may be given, or if, to dispose of the district its representation to the district commissioner, then that will suffice, Lord.
No, but what about this decision of the executive officer? Did it carry on? Can the deputy commissioner set aside the?
Otherwise, Lordship, because from our affidavit, is that without, they were running without a valid license and no pending application for renewal of the licenses there in their office, Lordship. So let it be decided by the district commissioner first, Lordship.
But that is not what your notice has said.
That is correct, Lordship. That is correct, but in our affidavit, we have stated that, Lordship.
You stated that, what does the Supreme Court say? Regarding affidavit giving different reasons. What does the Supreme Court say? I think you know better. Can you supplement the decisions made with the reasons given?
And Lordship may fix the matter on another.
No, I've heard you. Why should I've heard you.
I'll go to it, Lordship. I'll try to.
No, yeah, but I'm not saying anything. Let us see what you have said in your affidavit.
Paragraph 6, Lordship.
They have given reasons here.
But that is not, these reasons are there, but we have disputed that one. What is the finding, madam? Whether the inquiry was made or not made. Only to justify their blanket order, madam, they have given, subsequently they have given this.
But the problem is they mentioned says that later on they are going to justify it anyway.
Madam, they have no authority to pass this order. What is that mistake? If it comes under the act, competent authorities to pass the order. They cannot. They passed, initially they passed order because the commencement of the, your work kind of demand. Nothing. Now they are coming and saying that these are the things. And this reply you are given, you are saying, you are giving reply to that.
So basically it just says who are directly involved in selling of cow meat and products.
That is our professional mind of it. Things that
But then unless you challenge the law, then what happens?
No, I am not saying, but I shall follow it. I am ready to find out. I am ready to find out on my business in terms of this act. I am not running away. My question was, would have been inquiry or anything, can you pass this type of order, madam? Selling the 100 years of my business, my order. We are running now out of business, madam. We are now facing financial difficulties for last 2 years. Where the competent authority pass order, I have nothing to say, madam. We can accuse also competent authority also, madam. I'm not challenging this provision. Right? People are not in terms of the simple because common sense of the act, section 8, it is closed. Beneficiation and everything. That is I am only one that. I'm ready, my lord. Let the competent authority pass. I will
Competent authority under what provision?
Rule 9. Yes. Section 8, it is there. Section 8 itself.
So DC has been made a competent
Now,
authority.
now my rule,
He is the competent authority.
In all the districts.
Yes, yes, from the.
now rule 8, my rule 9, you will find it.
Correct. Heard Mr. H.R.H. Chowdhury, Senior Counsel, assisted by Mr.
A.M.
A. Mohammed. Learned counsel for the petitioner.
But if you want to start by rule 9 medicine.
Huh?
Rule 9 medicine, that will be, it will give some sort of help. Yeah. Rule 9. Yeah. Rule 9 application for the purpose of section 8. You're watching what is. Yeah. You're what it. For the purpose of section 8 of the Act, the intended citizen shall apply for the license for the beer shop in Form E as annexed in these rules to the report circle of which to the district magistrate of the district. Circle of which on verification of the details mentioned in the application shall submit a report and there is a proposal placed for. So this can be done also, madam, we are not shying away of that here. The executor is to go my lord and let the law take its own course.
It is very sensitive, so it is very sensitive, so whether.
So if it's sensitive, so what? That means the court, the high court should shy away from it.
No, no.
Yeah. I know it's sensitive. So that we should just keep it that no one should touch it. They have come to the court. We have got to pass an order whether it's sensitive or not. So that's it. Huh? We also have this as Rajkata Sarva, learned counsel for the
Respondents, sir.
respondent. Yes, sir. The petitioners are aggrieved by the notice dated 30/06/2023 issued by the executive officer, Sonari Municipal Court, by which the business of selling of beef is completely prohibited from the municipal area. From the municipal area of Sonari. From 15/7/20 as per section 8, the attempt reservation. From the section 8 of the Assam Cattle Preservation Act 2021. Herein after referred to as the Act. Next one. The learned senior counsel for the petitioner submit that the business of the petitioner has been going on since the days of their forefathers in the said area. And the act in question also does not contemplate a complete ban on the selling of weed, but only prescribes the procedure for running the said business. At that time, when the order was issued, who was the competent authority?
District Commission.
At that time,
Yes, because it was of
when page 28 was issued,
No competent authority was there.
no competent authority. And how can, then, who can issue the order? Who can issue a prohibition order at that time?
So but at that time only ministry, under municipal, municipal can act only on the basis of complaint. Only that can do what, section two hundred
No,
ninety.
but it has been done under section 8 of the act.
Section eight, no, not under section three. What they have said, you will kindly see, they are saying that because of the comments of the act. Yes,
Okay, they say it has not been done under this act.
no, under, they have not passed under this act. What they say, my lord, that business are completely prohibited in the municipal area as per section eight. Who, where is that going? They are saying that section eight completely prohibited. This is not correct.
And under section 8, the competent authority is someone who is appointed with respect to the. Okay. Yes, so what did I say? Ban. Next paragraph. The competency of the executive officer in issuing the said notice dated 36/22 has also been questioned by drawing the attention of this court to the act in question, which prescribes that the government should appoint an appropriate authority, which had not been done at the time the notice was issued.
But in our affidavit notice, page 38 notice.
Yes.
Second paragraph. Notice, we have said it, this further stated that the government of Assam by gazette notification has appointed a deputy commissioner of the concerned district.
Just
as
a
a
minute, page
competent-
38.
Page 38 for affidavit in opposition. Comes under paragraph 7, notice. Here,
Just a minute.
it comes
Now,
under,
this point number 4.
yes, of that number 4.
Para,
Para 7,
Eight thirty.
in the page 43 of it.
page
That with regard to the statement made.
no, from paragraph 7, logic. Page 37, the paragraph 7, logic. Page comes to page 38, logic. The page starts by second paragraph, logic.
Huh?
Page 36,
No,
page
no,
38, second paragraph, logic.
No, I don't have it. It is para, which para is it?
Paragraph seven.
How does it
Seven.
start? How does para 7 start?
That we trigger the
Yes,
statement.
please read that. It is page 43 in my.
That we trigger to the statements made in paragraph number 6 of the writ petition. Respondent begs to state a repeated admitted fact that assembly issued the notice, right, so this is so informing the general public of the municipal area that people who are directly or indirectly involved in the business of buying and selling of cow meat products made of cow meat, such business are completely prohibited by the municipal area from 15 July 2022 as per section 8 of the Assam Cattle Preservation Act 2021. It is stated that Section 8 of the Assam Cattle Preservation Act 2021 relates to prohibition of sale of beef and beef products and provides that no person shall directly and indirectly sell or offer or export for sale or buy beef or beef products in any form except at places permitted to do so by the competent authority, provided that no such permission shall be granted in such area or areas which are predominantly inhabited by Hindu, Jain, Sikh, and other non-Sikh eating communities or within a radius of 5 kilometers of any temple, etc., or other religious institutions belonging to Hindu religion or any other institution or area as may be prescribed by the competent authority. It is further stated that the government of Assam by gazette notification has appointed the Deputy Commissioner of the concerned district as the competent authority under the Assam Cattle Preservation Act 2021. So notice. Where is the position? Somehow we have not annexed the gazette notification. If your project permits me, I will confirm it when the gazette notification came.
Not error notification.
By of the appointment of the Deputy Commissioner of the concerned district as a competent authority under the Assam Cattle.
Where have you said that?
Authority.
Yes, so the competent authority should issue the order, not you,
Yes.
not the,
But my senior colleague is, stating that at that point of time, the competent authority was not appointed.
okay, no, forget that, but the competent authority did not issue the order. It was the municipal
Municipal.
board. Let the competent authority issue the order.
Without the restrictions.
Whatever I said. Appropriate to appoint to appoint. Competent authority. To exercise the power that functions under the act. He also submits that without completing the formalities prescribed under the act, which would include allotment of an appropriate site to carry out the business of the petitioner. A complete ban is not contemplated as that would amount to infringing the petitioner's rights to carry out their business. Mr. S.R. Barwa, the learned government council subject that the competent authority under the act is the deputy commissioner. He submits that the petitioners were not allowed to carry on their business as there are many other religious groups in the area. And that within 5 kilometer radius, there are more than 90 other religious groups such as Hindus, Jains, Sikhs, Buddhists, etc. Also, further, the surrounding area of the slaughterhouse was found to be very dirty and unhygienic, which threatened public health. The petitioners had also deposited renewal fees only up to 31/3/20. And no renewal application for the trade license has been made thereafter. As such, the petitioners were running their shop that slaughterhouses within the area of the Sonari Municipal Board without having any valid license, which was not permitted. That's your case. That's your case.
Yes, yes. And they have, they have already filed one FIR petition. So let us, competent authority decide in the matter and still they are not.
Just put that in Mr. H.R.A. Chaudhary, huh? Mr. The learned senior counsel for the petitioner submit that the petitioner has submitted a representation dated 3/7/22. No. To whom?
D7.
That is to the chairman.
No,
The
district
commissioner, yeah.
To the deputy commissioner. To the district commissioner, Charadio.
Sorry.
Charadio.
As well as
To allow them to continue their business. To allow them to continue to run their business. However, the same has not been decided till this. And as such, a direction may be issued to the deputy commissioner to consider the petitioner's application. Correct? Representing. With Sarah, after saying that, Sesa Barwa, at the end, they say, Mr. Sesa Barwa submits that as the petitioner has submitted a representation dated 3/7/22 to the deputy commissioner Charadio, district commissioner Charadio, the a direction can be issued to the district commissioner to consider the petitioner's representation and to take a decision thereon. I have heard the learned counsel for the part. The impugned notice dated 36/22 issued by the executive officer, Sonari Municipal Board, has given a blanket ban on the selling of beef and beef products in the municipal area of Sonari. In the Sonari municipality area, just in the Sonari municipality area, on the ground that, as per section 8 of the Act, no specific reason has been given by the executive officer as to which part of section 8 of the Act is applicable to the petitioner's case. In the case of Commissioner of Police, Bombay versus Vardhan Das Banji, AIR 1952, SC 115/9. The Supreme Court has held that public orders in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer making the order, what he meant or of what was in his mind, or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the acts and conduct of to whom they are addressed and must be construed objective with reference to the language used in the order itself. In the present case, the impugned order, impugned notice issued by the executive officer of the Sonare Municipal Board shows that the affidavit filed by the this point number 4 is to supplement the absence of reasons in the impugned notice by way of governments made in the affidavit, which cannot be allowed. The above being said, the respondent number 4, bracket executive officer of Sanari Municipal Board is not the competent authority under the Act. As he was not appointed by the government, by the state government, by way of a notification in the official gazette to exercise the powers and functions of the competent authority under the Act. In that way, the matter, the respondent number 4 would not have used up the powers of the competent authority and as such, the impugned notice barring the petitioner from performing his business from doing his business is arbitrary or has no prior notice, has no prior show cause notice has been issued to the petition before issuing the impugned notice dated 36. Consequently, in view of the above reasons, the impugned notice dated 36/2020 is hereby accepted. However, in view of the fact that the petitioner's license to run the business has expired,
Authority may be divided to go in terms of the law. They can go in terms of the law, either, because we have applied for renewal. We are getting the license.
So no, so till the renewal is given. So right now you are stopped, Till the renewal is given.
That is the
So
law.
let's so you'll go to whom?
I got
So renewal has to go to
competent authority.
Renewal the municipal board.
So renewal is municipal board, my lord, but the formal section 8 is.
how
Renewal is pending before then, money already deposited.
okay, how has the petitioner's license for running the business has expired
On
and the renewal application is pending before the municipal board. Comma. The petitioner shall not continue their business until the renewal of the license is approved. Is given by the municipal. Full stop. Further, as the petitioner's representation before the deputy commissioner, Charachi, district commissioner, Charachi, is pending. The district commissioner shall consider the petitioner's representation and take a decision on the same within a period of 1 month from the date of receipt of a,
From the receipt of the
from the date of receipt of a certified copy. That is petition to foreign report.
One thing in the meantime, because we applied for it, nobody what to do my God. Nobody takes effect on the my subsequent.
But now the problem is 2 years have passed. That is the only problem.
We can immediately before this, that way, what is the possibility?
Now you wait now. 2 years have passed. Now to allow you to, when they have taken a stand, that the renewal is not there, and it will not be proper.
Now, they will not issue renewal might have been because of this act. They will not, because you was there. They will say that because of this act, there is no question of authority.
Huh?
Because of the act, commencement of the act, there is nothing on our part, they will feel like this.
No, but then what to do? The deputy commissioner have to take a call. Let the deputy commissioner take a call, then you go to them. Or should we say that
Yeah.
after?
Yeah.
Then they can take a decision depending upon the decision taken by the district commissioner.
Yeah.
Yeah.
Can I say that?
That will be.
Okay, what am I saying?
Renewal of the license.
The renewal of the license shall depend upon the decision to be taken by the district commissioner. Correct.
Of license.
It is safe, everything is safe.
Exactly.
It is everything.
There are two petitioners,
Dates, yes,
dates, everything.
there are four petitions.
Okay, four petition. Anyway,
That's
dates are same,
Yes,
notice same, everything.
dates, date, everything. All right.
Today morning, they have communicated me with notice letter. Actually, 10 days, yes,
The last occasion I handed over the copy of the contract agreement to them to verify whether there is any clause requiring us to submit forest clearance certificates at the time of payment.
10 days time may be.
For what?
Wherever comments not received, madam, they are. per-
Why, what is the requirement of paramedic? Have you brought the,
And on the sixth, witness this. They will provide, and I will, file the affidavit. Witness the minor,
Wednesday you file affidavit?
my,
There is no such clause.
Huh?
There is no such clause, my friend.
I know, but they want to file. He's, but you have to file, if you don't file, we are disposing it.
I,
Miss
am that.
M. Das, attorney for the forest department
No, I don't need of it.
of PWD.
150.
Oh, this is different, okay,
Right.
this is different, I thought I was thinking of some forest royalty.
It relates to forest royalty, my lord, the amount has already been deducted by the PWD authorities.
Okay,
Now, my lord, after the judgment came of this, from the.
yes, yes,
Court,
yes.
They issued this impugn letter, like, asking us to produce those certificates. There is no such clause. So this is under threat.
Miss M. Das is given a last chance to file affidavit in a position. So he submit that she will submit the same by Wednesday. Leave the matter on Thursday.
This case, if our lordship takes up, an affidavit has been filed day for yesterday. I need to file a short reply. Is it at the time 1 week time? Where my lord, essentially entire structure of the case is changed. So I need to file an. 1 week time. So you can fix up.
So as a structure change,
My lord, we have filed an affidavit, but that is being on record. An infringement petition filed in the previous. So that would adjudicate the matter. I'm not hinting at that, but I'm hinting at. Also, their case was something else. Now they have come up with a deal that there is no clause in the contract whereby the contractor is bound to accept the earlier contract. So that, in that sense, I'm saying it will change the structure of the case. So, my lord, here I need to.
you see, and the problem is now he's been pushing this court a lot to have a hearing.
No, we are not shying away
I
from
know,
hearing.
but you think that it's being delayed, so it's being delayed. So,
Only, my lord. Not can fix a date.
okay, that's-
Where I
When-
think
when-
apart
when
from
can we have-
me, I think my learned friend's role would be more important because what is the right of a contract labor in such a contract of peace? The earlier case that we have been. During the signature of this case, they are contract at the party. So the contract on their part to see that system, now they have. These are all on the realm of merit, my lord, plus we can give us. He's going to see. Whatever when it goes, it is a case of fraud committed by a government organization on a private party. Actually, wrongly goes out the this is a case of.
okay, when do we do? Thursday. Right.
My lord, Thursday, keep our 20th. Tuesday. Let it be, my lord, 25th.
Those will be motion days.
Tuesday, my lord.
So the whole week might be motion days because the last week of vacation before Friday.
My lord, then have it on 21, my lord. 20, so many matters. 21. Wednesday, my lord, what happens Friday, better than your lordships are. Piece of motion matters and efficient matters. Or even I can agree to 19 also, but not 20. 20 I'm already, my lord. Either 19 or 21.
Okay, let's try 21 if possible.
Yes.
We'll try. Let's tell them 21, let's see. Huh? No, but there's too many then. Now all tender matters, so everyone is in a hurry.
And we have waited for 1 year, my lord. No, my lord, that is because.
So why did you file the affidavit? You should not have filed.
Well, this is what has happened. My lord, that is what. It's a case of fraud, my lord. It's accurate on the face of the record. So we have to bring that effort. That's if the allegation is so serious, we need to rebut.
Okay,
Therefore,
Alright.
yesterday only it was.
right, Mr. K. Chaudhary submits that he appraised that he may be allowed to file a additional affidavit to the affidavit filed by the petitioner. Press allowed. And the additional affidavit should be filed on or before Wednesday. On or before Wednesday.
By 20, we'll file, my lord. 21 lots will come.
On or before, no, Wednesday. Because it doesn't come in the file format.
No, we'll ensure it comes, my lord. If necessary, in the morning, we.
On or before 20,
Ah.
I'll leave the matter on 21st.
Yes. Have we taken over the first item? Yes, we cannot.
First item to motion. We cannot
We
file
will
it. We will try and pray that day maybe at 2 o'clock.
With the understanding, it will be taken up at 2 o'clock. That's the best.
Let's see.
Take time. Oblige.
Let's see the lordship. Lordship matter pertaining to
Hiring charges.
pending charges and they have admitted
Where's the admission?
lordship in their affidavit in opposition. Para 3 lordship. Para 3.
Let's see.
Para 3 of affidavit in opposition. By respondent number 4. Respondent number 4. I said.
I don't have it.
Which one? I think it is not on record, the file on 11/6/24. Oh, it's not there. Not there. Today started. Para 3 was happened.
Let's see.
They are affidavit in opposition.
Okay. We'll dispose on this.
We have sent the proposal to the DPP.
When did you send?
It's not like
When did you send?
on 3/5/2024.
We'll give you time. We'll give you time. But you have what to pay. Huh?
Director General of Police.
So what? If he doesn't appear. The Deputy Commissioner of Police has said that, what else? If he doesn't want to appear, what can I do? I can't beat him and tell him to come. He's got so many police force, he'll beat me itself. But I got to pass an order on him.
What's it?
No, basically you have admitted. Once you have admitted, what remains?
Has to be sanctioned from the DPP.
So we'll direct, that's why we're going to direct the DGP.
DGP.
He has to pay. If he doesn't pay, we'll see. Heard Mr.
PK Mishra.
T.K. Mishra, learned counsel for the petitioner. Also heard Mr. S.R. Barwa, learned counsel for the
Reference number 2, 3, and 4.
2, 3, and 4, and Ms. M.D. Bora for point number 1. The petitioner has paid for a directive to release the pending bills pertaining to the hiring charges of his vehicles by the Commissioner of Police Guwahati, amounting to rupees 29,12,740. The petitioner's counsel submits that though the petitioner had submitted 12 bills in respect of the various vehicles for the total amount of rupees 29,12,746. The authorities have not paid the hiring charges to the petitioner till date. Mr. S.R. Barwa, learned counsel for the point number 4. 2, 3, and 4. 2, 3, and 4. 2, 3, and 4. Submits that. In terms of the affidavit filed by, that is point number 4. That is Deputy Commissioner of Police, bracket ADMN, bracket close Guwahati. The records pertaining to the higher charge bills of the petitioner were checked, were verified, and the claim of the petitioner was found to be in order. Further, the bills payable to the petitioner amounting to rupees 29,12,746 have been forwarded in two proposals to the Assam Police Headquarters, Guwahati, that is the sanctioning authority, to accord sanction and allot fund required for making payment to the petitioner. Once fund is received from the Office of the Director General of Police, Assam, Guwahati, necessary steps will be taken to furnish the, to pay, to disburse the same to the petitioner. On perusing the affidavit of the respondent number 4, I find that the state respondents have admitted to the fact that they owe rupees 29,12,746 to the petitioner and hiring charges for his vehicle. So DGP should do a recheck, I think. Gustav. In view of the judgment of the full bench of this court in Tamsher Ali versus Union of India, reported in 2008, 8 SCC, what? The head of the department has to verify the amount claimed. Gustav. As such, the Director General of Police, Assam, is directed to
There may be an upper limit of it. Let them be given 3 months, 4 months, but there should be a specific upper limit. of it.
should verify, should re-verify the, should re-verify the claim of the petitioner, which has been admitted by the respondent number 4. So thereafter, the admitted amount should be paid to the petitioner. So the entire site should be concluded within a period of
4 months.
within a period of 4 months from the date of receipt of a certified copy of the document. This petition is accordingly disposed of. Yes, what is the Tamsher Ali? What is the 2008? Okay. Give us citation. Okay. Oh, Mr. Yes, Mr. Very important. Mr. A. Chalia appears for the respondent number 5. Whatever I said at the last paragraph, please. After we bid to the petitioner, after ensuring that the funds are made available. No, after, after ensuring, thereafter, funds should be made available by the petition, by the respondent,
I recommend for the transport department, the finance department.
by the respondent, and thereafter the admitted amount to be paid to the petitioner. That's so that within a period of time. Within a period of 4 months.
I'm obliged. Okay.
But that is not a good order. This specific data also put that for. But I only have my fund. I have protection at that.
No,
मतलब
no, they will not make you a party. You've got no role to play. Don't. Okay, the review petition is allowed. This petition is. Contempt petition stamp to. Okay.
Item number 24 to 26 are connected matters, Mother. Lordship may kindly take up item 26 first, Mother.
Oh, we finished all the others.
You wanted it, Mother.
Oh. Yes, yes. He had prayed for it. Okay, what's this matter about? Huh? Huh? Interim order for 2 years. Interim order for 2 years.
Mother, may kindly take up item 26, which is WPC 39.
Where is it all? All these 3 petitions have been filed by you. Yes. So what is the case?
My lord, I'll very quickly narrate this question. So in item number 26, which is WPC.
No, just tell me from the beginning, everything will be.
Yes, everything is connected. One matter would suffice. In fact, in one matter would.
Yes, but it's the.
So, my lord, so initially, the petitioners were settled the fishery matter in the year 2808
Just a minute, on the basis of NIT dated,
on the basis of an NIT, my lord, which my
Dated?
lord would find the settlement order at page 29.
now what is the NIT dated?
So, my lord, NIT, I'll just come to that, page 29. So that is admitted.
No, I want to know, you see, I write down all these facts.
So, my lord, the NIT is dated 7/7/2015,
7/7/2015.
7/7/2015, and it has a memo number, my lord.
Huh? It
There's
has
a memo number.
just a minute. 20. Okay, where is the NIT page?
NIT, the type copy at page 29. The original copy at page 31, one, which is in vernacular. So initially, the petitioners were settled.
Wait. 29 is not the NIT.
Last.
26, what 26? Page 29 is the settlement order.
No, it's WPC 3966, the last matter, 20.
3966. I've got page 29 in front of me.
3966, page 29 is the, my lord, annexure.
This is a settlement order.
Yes, that.
Where is the NIT?
NIT are not anything. NIT is
NIT is not there. So page 29,
page 29, my lord,
settlement order dated
28/08/2015. I'll read it out, my lord.
Yes.
With regard to the subject and reference cited above, it is to inform that the tender submitted by you on so and so on 7/7/15 for Borpana fishery of Borpeta district under corporation is hereby accepted, fixing 13,63,000 as annual revenue for the financial year 2015 and 16 to the financial year 21-22 till 31/03/2022 for a period of 7 years. So, my lord, the fishery was settled for a period of 7 years till 31/03/2022. While the society was running the fishery in the year on 15/12/2020, my lords, Annexure B,
15/12/2020.
15/12/2020, during the currency of the initial period of the tender, an order was issued by the AFC. Now, that order, my lord, you find at page 32. With my lord notes, my lord, that's 15/12/2020. It's in the midst of the COVID-19 pandemic. So this order has been issued. I won't read the entire order, my lord. Page 32. The second,
15, 12, 20, 20, is it 2020 or?
12, 2020.
Huh?
5, 12, 2020.
Yes,
My lord, the second and the fourth paragraph, the second paragraph for example. Hence, project manager of Borpeta district is directed to manage the field in district management system of AFPC to engaging Dinobandhu Nayak as stakeholder management and Shri Arun Das, Messrs. Bampara Fishermen Cooperative Society of Borpeta district for a period of 4 years with effect from 1st of April 2021, which may be extended for another year, another 7 years, subject to satisfactory management of 4 years against the target value of 14,88,300 per year up to 4th year and with an enhancement of 20%, which is 17,86,000 from 5th year onwards. However, AFPC may review and refix the revenue and production subject to ecological and environmental condition and status of the place. The fourth paragraph, my lord. As the society has requested to merge their period of settlement, which is till the year 21-22 in direct management system for better management and enhancement of livelihood of the poor SC fishermen of the society and to compensate the loss incurred during COVID-19 and the loss incurred by the society for the last 3 years due to wedge and forge. I don't understand what means wedge and forge allegations. Their prayer is specially considered and modified the previous settlement order. So the settlement order, which I produced, which my lord has produced at page 29, was modified. By way of this order. And my lord notes the second last paragraph. This arrangement is made due to norms and status of COVID-19 and financial crisis of AFPC. This has the approval of the Honorable Chairman of AFPC and it is signed by the Managing Director AFPC. And my lord would also see, my lord, it was put under direct management system and the revenue was also enhanced. So, my lord, the earlier revenue was 13,53,000, which was by way of a tender. It was enhanced to 1,35,000 for a total of 14,88,000. So, pursuant to this order, my lord, if my lord turns the page, the petitioners had requested to develop the fishery at their own cost, my lord, which was agreed to by the AFPC, which my lord will find at page 33. It is dated 28/1/2021. Sir, with reference to the subject cited above, I would like to inform you that the Assam Fisheries Development Corporation has no objection for taking 4 ponds within the area of Borpana field in Borpeta district subject to protection of ecological status of the field and the damages of the field environment with the following condition. All expenditures must be bared by the stakeholder. No claim would be accepted in the future, so and so. The plain construction of the ponds has to be certified. Works will be supervised by the field officers of the age.
So this is as per your request.
As per my request, we have developed the fishery and
That has nothing to do with this case.
my lord, thereafter, my lord, annexure D is the agreement which was arrived upon by the AFPC and the petitioner. This is an agreement, my lord. Thereafter, my lord, while
Just a minute. Agreement dated 5/12/2020.
1/7/2021, my lord, the agreement. In
Uh-huh.
terms of the order, which is, my lord,
Okay.
dated to the-
Agreement dated 1/7/2021.
1/7/2021.
1/7/2021. What does it say?
So the agreement, which is in terms of that order, which are already shown, my lord, direct management order, annexure B, my lord, the PPP order, my lord.
On what ground has he done this? What is the- How can he do it for how many years has he done?
For 4 years, my lord. But this was during the currency of my original period of settlement, my lord, which was by way of a
No,
tender.
by PPP mode. How can under PPP mode it can be born?
Yes. I'll come to that, my lord, underneath my argument. Thereafter, my lord, as matters remain does, my lord, on 8/4/2022, page 37, annexure E, all of a sudden, my lord, without granting any opportunity to the petitioner,
8/4, page
page 37, an order was issued by the AFTC whereby my settlement was sought to be cancelled. Page 37, I'll just read the first line, my lord. A list of deals under AFTC comprising of different districts of Assam, which were settled without inviting tenders, under different modes having no interim protection from the Honorable High Court, are placed before me by the Office Superintendent to pass necessary order in connection with so and so. The bills which are placed before me are, I'm at serial number 1, Borpana bill. Admittedly, my lord, this order was issued.
Yes.
This order was issued on the basis that the settlement, the initial settlement was not made by a tender, which is perfectly wrong, my lord. Because in my case, I'm not for the other fisheries, my lord. In my case, there was a valid tender process. The tender,
But your case, your tender was only for 7 years.
Yes.
Was there any ground for extension of the 7-year period
Yes.
in your agreement?
like I read it, my lord, because of the COVID-19 situation and the PPP, they have extended the period, my lord. And extension, my lord, they had extended for 4 years. It was, my lord, if I may calculate, the initial settlement was till 2022. In the year 2020, they had extended it for 4 years. So meaning thereby there was the extension of only 2 years, because till 2022, I already had settlement file of a tender. So,
So it was extended
Yes.
from 2020.
2020. During the currency of my original period, my lord, which was till 31/3/2022. So pursuant to this order, my lord, what the respondent AFTC did, they issued a tender, fresh tender, whereby my fishery was sought to be tendered. Then I approached this Honorable High Court, and by way of writ petition at serial number 25, my lord, which is also before your lordship, and there was an order of status quo granted in that writ. Thereafter, my lord, in spite of the grant of interim protection, the AFTC had issued another tender, my lord, a revised tender, whereby again, during the currency of the order of the Honorable High Court, they had issued another tender whereby again my fishery was sought to be tendered. And that is why I approached this Honorable Court by way of this writ petition, item number 26. My lord, this was also challenged and there was an interim protection granted, my lord. Now the grounds on which the grounds of challenge, my lord, the first ground that the impugn order of cancellation was issued in violation of the principles of national justice. So admittedly,
Order of cancellation dated
my lord, the order of cancellation, the first one is, my lords, 8/4/2022. Thereafter, my lords, the tender, my lords, again, annexure F and annexure A.
tender dated
Tender is 02/2022, my lord. Just a minute. 02. My lord, just give me a moment. Thank you. 29/4/2022, my lord. Page 42. Page 42. And the last impugn order is the revised tender, my lord, which is challenged in this writ petition, which my lords would find at page 47, annexure H. It's a tender dated 3/6/2022. The first Intune order, my lord, which is dated 8/4/2022, whereby my settlement was cancelled. It was cancelled on the ground, not my settlement. There were a number of fisheries, those were thought to be cancelled. It was on the ground that there was no tender first, my lord. Second, my lord, there was, it had caused loss to the AFDC, such settlement. And third, my lord, it was against the ratio laid down in a case namely Haria Dablon, which has been rendered by a full bench of the honorable. I'll come to that. So my grounds of challenge, my lord, my first ground is that while issuing the cancellation, I was never granted an opportunity. First, my lord, there was violation of national law. Second, my lord, as I have shown, my lord, and it's my pleaded case that person to the settlement and person to the order, my lord, and also the agreement, we had made substantial developments to the fishery, my lord.
That is your own risk and cost, that doesn't give you anything.
No,
Your
come to that what-
substantial development
yes,
was not on the basis of their directions to you or orders to you.
yes.
That was at your own risk and cost you've done.
Exactly. But nonetheless, my lord, in my humble submission, since I was given the impression, by way of a order passed by the respondent and also the agreement arrived between the parties that I would be settling with the tender for 4 years in 2024. So I had made investors and
That would end when, according to you?
according to me, my lords, that should end. If it is 5/12/2020, another 4 years would be 5/12/2020. 4/12/2020.
Why should it be 5/12? Why, what's wrong with it 5/12?
4/12, my lord, because the order, my lords, the direct settlement order at page 32. The order is dated 5/12/2020. But PPP for 4 years with effect from 1/4/2021. So it will be 2025, my lord. I'll come to the order again, my lord.
Whether it's a 1/4/20.
Page 32, my lord. Yes, the second paragraph, my lord. The fourth line. Period of 4 years with effect from 1st of April 2021, which may be extended for another 7 years, subject to not concerned with that.
This is a joke.
4 years.
The officer is a joke. He's thinking this is private property. Yeah, for 4 years and then 7 years again, man.
Maybe. I'm a stakeholder. I'm a power person. So, speak to us.
Yes.
Yes. So my first ground was, my lord, that there has been violation of principles of national justice. Second, my lord, that since I was given the impression that it would be extended for 4 years, I had altered my position, my lord. I have altered my position and that would call for the principle of promissory estoppel also. My lord. I'll try and satisfy your lordship. I'll place some judgment on it. Third, my lord,
Yes, sir.
third, my lord, the order by which the settlement, my settlement was extended for a period of 4 years. That was not a fresh settlement, so as to take into so as to, my lord, into the Intune order, because that Intune order said that fresh settlements which were not made inviting tender. So my ground is, my lord, that the order dated 5/12/2020 was essentially an extension of my initial period of settlement, which was setting by way of a tender. Now, this question that I know whether at all the AFDC has the power to extend a settlement. If it is initially settled by way of a tender, whether the AFDC has the power to extend the settlement.
If the extension happens when the period expires.
Because At that point,
Why is the extension allowed prior to the period expired?
so my lord, the order itself is
Also,
self-explanatory, my
It is
lord.
also made in 2021. While your period would expire in 2020.
So my lord, that's the third ground. Fourth, my lord, they have said it has caused loss of revenue to the AFC. But if my lord compares the initial settlement and the order dated, my lord, and the order dated 5/12/2020, my lord would see there has been an enhancement of the revenue.
And advent of revenue because they're dealing with only you. If it was in a tender process, then there would be competition.
And that's and my lord, my learned friend
Yes.
would produce, my lord, the judgment rendered by a coordinate bench, my lord,
Ah.
rendered in WPC 2192 of 2022, whereby a number of similarly situated fisheries where settlement has been made by way of PPP mode were cancelled, and that was upheld by this honorable, the coordinate bench of this honorable. But my lord, even these matters were tagged with the matters which were dismissed by the honorable single judge. But the honorable single judge had observed that our cases stood on a different footing because of the fact, my lord, that all the other fisheries which that judgment dealt with, they were all settlements which were fresh settlements by way of PPP. And in my case, there was initially a tender process by which I was granted a settlement, and thereafter there was extension. So these matters were segregated. I'll place the judgment, and I'll just refer to a paragraph, not only a paragraph. I have a copy of the judgment. This is the judgment rendered by the coordinate bench, my lord. Here it was held, my lord, before my lord, I take my lord the judgment, that the principles of natural justice won't be attracted, and that would be a useless formality because the initial settlement was without inviting tender. So the court had held that there was no requirement, for natural justice. My lord would come to paragraph 40 directly. Paragraph 40, which my lord would find at internal page 45. She's married, my lord.
Yes.
Sri Sharma, learned standing counsel, further argued that in case of the present nature, the principles of natural justice will not have any role, inasmuch as since the initial process was absolutely illegal, no right whatsoever had accrued upon the petitioners, and therefore they are not entitled to any opportunity for taking a measure to rectify the action. In this connection, the learned standing counsel has placed reliance on a decision in the case of Dharampal Satyapal versus so and so. So my learned friend relied on Dharampal Satyapal to show, my lord, that any natural justice were not called for in these batch of writ petitions because the initial settlement was illegal because the initial settlement itself was on PPP. So these matters which my lord is dealing with now stood in a different footing, and that's why these matters were segregated from the batch of writ. Now, my lord, if my lord may take up the same thing.
Those PPP modes matters were done without sense of
Yes.
tender.
They were directly given PPP mode.
And let us see your case further.
My case, there was a tender process, my lord, therefore there was the extension, which I say is an extension by way, and that is the reason why it was modified. And surprisingly, my lord takes up page 45 again. Kindly, my lord, page 45.
Yes.
The first paragraph, the first three lines, the submission of my learned friend appearing for the AFP. Page 45.
Yes.
The first paragraph, the third line from the bottom, from the first paragraph. He further submits, though PPP mode per se may not be illegal. Page 45. Page 40, internal page 45 of the judgment. My lord. I'm so sorry, my lord.
Yes.
First paragraph, my lord. The third line from the bottom of the first paragraph. He further submits that though PPP mode per se may not be illegal and may be an accepted mode for the authorities, the same has to be done strictly by following the procedure laid down in the. So what is the procedure? The procedure, my lord, my learned friend guide, according to me, we are just settlement holder of fisheries, my lord. That was the order issued and we were. Page 45 of it. Page 45. So, my lord, it was the submission of the standing council AFDC that PPP per se is not illegal. Now, my lord, there's another aspect to it, my lord.
What is the court hold?
The findings, my lord, would find from paragraph 47. The court had held that there was no requirement to give any opportunity because the initial settlement. Page, paragraph 47, my lord. Internal page 49, paragraph 47. The issue which arises for determination in this series of cases is as to whether the action of the AFDC in cancelling the settlement order in favor of the petitioners relating to various issues is sustainable in law. However, to answer the said issue, it has to be first examined as to whether the initial settlement was done in accordance with law. The answer to the preliminary issue regarding the validity of settlement made with the petitioner would lead this court to take into consideration the various grounds urged by the petitioners, including the ground of violation of principles of natural justice before such cancellation. In other words, the court is also required to examine with the same yardstick with regard to the application of principle of natural justice can be applied in case the initial order of settlement is held to be in accordance with law and if such settlement is held to be done illegally. So, my lord, the final findings, my lord. All the matters were dismissed, my lord. Paragraph 58 also, my lord, would find that the initial order was absolutely without the sanction of law.
Para 58
or 58.
or
Page 55, internal page. 58, 59, 61, my lord. I'll not trouble my lord with reading the entire. My lord, there's another aspect, my lord.
para 50 clause 4 of the judgment.
Yes.
Says here that we may, however, like to add that extension of fishery creates unnecessary problems. And as such, definite criteria of parameter may be laid down,
That, my lord,
or some alternative may be found to reduce the proper and suitable.
I'll come to that judgment, my lord. If the honorable court was referring to a judgment, full bench judgment, higher judgment, I'll. But, my lord, this is a judgment rendered by a single bench of the honorable court, cannot be a court member. My lord, there are.
So this is a full bench, is mentioned.
The judgment referred is a full bench judgment, but this judgment is by a coordinate bench, my lord. And there are three other coordinate bench judgments, my lord, wherein under similar circumstances, even when the initial settlement was under PPP mode, this coordinate bench had held that no, even then the principles of natural justice has to be complied. For your, I'll just, my lord, for my satisfaction, I'll just say that. This is a judgment rendered by Honorable Justice Debashish Borua, my lord. Again, PPP settlement, my lord, without inviting tender. But nonetheless, my lord takes up paragraph 9.
So your settlement was done in a PPP mode. Your extension done PPP mode.
Yes, I call it an extension because it uses the word that.
No, whatever it is, it's
Yes.
by a PPP mode. So it's a different method.
My lord, I take up paragraph 9, internal paragraph internal page 4. That will. Paragraph 9. This judgment is dated, my lord, 11/1/2022, and the other judgment that I have referred, my lord, which my learned friend also refers to, it is dated 21/09/2022. So, my lord, this is an earlier judgment, my lord. Judgment rendered by Honorable Justice D. Bodo, my lord. Paragraph 9. I have heard the learned counsel of parties at length, and having heard so, and after taking into consideration the materials on record and taking into consideration the rights of the petitioner, which stood approved on the basis of the agreement entered into. This is the same agreement, my lord, which in the instant case has also been entered into by the parties. I have shown it, my lord, which is an annexure C. Has on the basis of the agreement entered into on 4/12/2021 and negation of such rights without following the principle of natural justice would violate the mandate of Article 14 and 19(1)(g) of the Constitution. It is directed that the respondent authorities, before taking any step in terms of the order dated 15/12/2021, shall issue a notice upon the petitioner and give a reasonable opportunity of hearing to the petitioner. It is made clear that the respondent authority would be absolutely within its jurisdiction to take any decision as being fit in accordance with law after hearing the petition. So this judgment, in my humble submission, directly contradicts the ratio laid down in the other judgment, my lord, which I have referred, my lord. The judgment rendered by Honorable Justice.
Which para?
Paragraph 9, my lord.
No, in the earlier judgment,
Earlier, my lord, that no rules of NJ won't apply.
para.
Just a minute. In paragraph 47, has been referred to again, my lord, I'll come to that. Then 57, my lord had referred to the Aligarh Muslim University case. That giving natural justice is a useless formality. And 58 again, my lord, that the initial settlement itself was without sanction of law, therefore. And 59 also, my lord. 59, 58. My lord, this is not just one judgment which contradicts. There are another two judgments of coordinate bench. I'm situated on a better footing, my lord. At least my initial order was by way of a tender. This matter, my lord, which I had just referred to, it was directly settled in PPP board, but nonetheless, my lord, the Honorable Single Judge had held that the principles of natural justice have to be complied with. Similarly, my lord, Honorable Justice Pathak had also rendered two judgments, my lord, on similar footing as Honorable Justice Pipol. I'll just take it. My lord, may first take up the judgment, mainly Krishna Mani Das. I directly come to the paragraph, my lord. The paragraphs are not numbered, my lord. My lord, to come to internal page number 4. The second last paragraph from the bottom. It is also seen, yes, my lord has it. It is also seen that though necessary amount, security deposit, requisite test money, etc., have already been received by the respondent AMTC, on being deposited by the petitioner in terms of the settlement orders dated 14/5 so and so and 2021 for settlement of those tanks on number so and so, so and so, so and so. But the respondent AAPC has passed the impugn order, impugn order dated 15/12/2021 unilaterally, cancelling such settlement with the petitioner without giving him any opportunity of hearing, in violation of the principles of natural justice and violating the provisions of Article 14 and 91D of the Constitution of India. As such, this writ petition is disposed of as at motion state itself, directing the respondent authority, the AFDC, that before taking any steps in terms of the impugn order dated so and so, it shall give a reasonable opportunity of hearing to the petitioner, and thereafter it can take any decision in accordance with law within its jurisdiction. So this is one, my lord. The another one, this is also authored by Honorable Justice Pathak, my lord. Same, my lord. Here also, my lord, internal page number 4. The third last and second last paragraph. Similarly worded. So, my lord, there are 3 conflicting judgments, which is against the judgment rate. But, my lord, in my humble submission, I am not covered by the judgment rendered by Honorable Justice. My lord, Honorable Justice Methi, my lord, because I stand on a different thing altogether. Why, my lord? I'll for that purpose, my lord, I'll create a judgment. Hurry up, no? The learned single judge, my lord, in that case had referred to the full bench judgment, my lord, rendered in Haria Tapla. It's, my lord, reported in 2001 to GLR 333. In this matter, my lord, the Honorable Full Bench was discussing the ambit of the powers of AFDC, whether they had power to settle fisheries and what were the circumstances. What? So, my lord, here I'll directly come to the finding, which my lord would find at at paragraph 26, is page number 344. In view of our foregoing discussions and decisions, we answer the question as raised as follows. The Assam Fishery Development Corporation has the sole authority and jurisdiction to lease out stroke settle the fishery which have been transferred or vested with them under Rule 8C2 of the Assam Fishery Law. The AFPC has no power to make direct settlement. As per proviso to Rule 12 of the Assam Fishery Rule, the Director AFPC shall have the authority to make settlements, and for that purpose, defined guidelines defined guidelines may be laid down so that there is transparency in the matter of settlement. The need for transparency need not be de-emphasized in view of the patina of judgments, decisions of the apex court on this point. But number 4 is important. Lordship is skipped 3. As the AFPC has been found to have powers to make settlement in respect of fishery vested with them, they have the implied power to pass orders regarding extension of settlement. Lordship, kindly note. Says, my lord, they have the implied power to pass orders regarding extension of the settlement. So in my submission, in exercise of these powers, my settlement was extended. Why it was extended? It is there in the order itself because of the COVID-19 pandemic. Whether it was rightly done or wrongly done, my lord, because they would be privy to that. And my learned friend has submitted that vigilance cases have been, but in the affidavit in opposition, which they have filed, there's not even a word, my lord, that why the chairman had approved. It's the same chairman, my lord. Why the managing director had extended. So my point is, my lord, since, my lord, an extension would not be wholly illegal, since that power at least is there with the AFTC. Therefore, my lord, it cannot be said that the PPP order is wholly illegal, because that was not my initial settlement. Because I was awarded the fishery, or rather settled the fishery by way of a tender, that is an admitted fact. And during the currency of the tender, there was extension of that fee. So therefore, my lord, in my humble submission, that it won't attract the principles of useless formality. Because for useless formality, it has to be shown that even if natural justice would have been, the opportunity would have been given to the petitioner or a person, no, there would have been no difference. So in my case, my lord, since the AFTC had the power, the implied power of extension, and that was done. So it is not wholly illegal. Therefore, at least the basic minimum, what they should have done was to give an opportunity to the petitioner, which was not done. Now, my lord, there are other grounds which I've faced, the ground of promissory estoppel. Since, my lord, there was an agreement and there was an order, I had made investment and I had altered my position. And even in a public law remedy,
But no. You see, that is only when the other side asks you to do it. In this case, there was no promise made by them.
no.
It was your own. You can see from the letter.
Exactly.
It was your asking.
Yes.
It promissory estoppel only occurs when the government asks you to do something and then you change your position to your detriment. Out here, the government didn't ask you to do anything. You change it to your detriment.
That is correct.
Then
that is
there's
correct,
the
but-
question
but-
of promissory estoppel
but
does not
you-
arise.
In my humble submission, why promissory
Well, I
estoppel?
have taken note of that. Then next, what is the next point?
Yeah, because the representation, I'm running a fishery here.
Maybe
If I'm
You-
given extension,
you want
I
to,
would
you want to develop, you
I
develop.
would do the best for the fishery, madam.
You
I
do
would-
it. You
I-
do it.
I mean,
That is not for, that you're not doing it for the government, you're doing it for yourself.
that is the reason, madam, because they had made an express representation.
You see, no one asked you to do it. No one asked you that once you have settled with the fishery, please do this. No. You, in fact, when did you ask for the development of the fishery?
That
The
is
year?
one letter, madam.
When was that?
That was, my lord,
That was in the year when?
that was in the year 2021,
2021. And you started the fishery when?
2015.
So why didn't you do the development long time back? You would have earned more.
No, madam.
Anyway, that is one. The next, that is not waste time. We will report whatever you say.
I'll place the judgment, please.
Yes, yes.
My lord, may I first take up the judgment, which was judgment rendered by the Honorable Supreme Court in Dharampal, where it was also referred to by the single bench. And the citation is 2015 8 SCC 519. So this judgment is destined to survey in cases where the party want to show that the principles of natural justice are not required. It's an useless formality in cases where
This is what regarding promissory estoppel
this is
or
regarding
principles of natural justice. What?
yes, useless formality.
Principles of natural justice.
Yes. So here, my lord, one paragraph is never noted, my lord. That is very important. Paragraph 42. Paragraph 42. Internal page 540. Paragraph 40.
Yes.
So far, so good. However, an important question posed by Mr. Sorabji is as to whether it is open to the authority which has to take a decision to dispense with the requirement of the principles of natural justice on the ground that affording such an opportunity will not make any difference. To put it otherwise, can the administrative authority dispense with the requirement of issuing notice by itself deciding that no prejudice will be caused to the person against whom the action is completed. The answer has to be in the negative. It is not permissible for the authority to jump over the compliance of the principles of natural justice on the ground that even if hearing had been provided, it would have served no useful purpose.
Okay, their judgment decide that side, normally CIL.
What has been held here, the AFDC could not have dispensed with the principle.
That we will decide, those issues will decide.
That my lord may decide, of course.
Yeah.
My lord may say,
So,
it's
because this, we'll see this decision, and then we'll, probably he's there to bring out ECIL decision or something. That,
no, this is
so-
state, my lord.
so anyway, so, yes,
This covers the, this
this
says
according
that-
to you covers the field, maybe according to may not, so we'll decide that. I have taken note of.
I won't trouble, my lord.
Next point.
Right.
You've taken already 1 hour. Nearly enough. How much more time?
10 minutes. On another judgment, my lord,
On the same point,
on promissory estoppel.
promises.
Citation is, my lord,
Yes.
19 AIR 1968 SC 718. So this is the celebrated case, my lord, Indo-Afghan agency,
Yeah, 98.
AI 1968 SC 780. 718.
So, wait, para,
Paragraph 20,
20,
21,
21.
24.
Yes.
To the paucity of time, I won't read. The another judgment, my lord, Aligarh Muslim University,
Yes.
is reported in 2007 SCC 529. Yeah, my lord, would allow me
2007.
2007 SCC 529. 529.
Para,
Paragraph. Here, my lord. Paragraph 20, paragraph 19, 21, 22, 23, 24, 25. It discusses the user formality theory. And the most important paragraph is paragraph 34, which is a very short paragraph. I'll kindly allow me to do. We may add a word of caution. Care must be taken wherever the court is justifying a denial of natural justice, that its decision is not described as a preconceived view or one in substitution of the view of the authority who would have considered the explanation. That is why we have taken pains to examine the depth whether the case fits into the exception. So that word of caution has been added by the Honorable Supreme Court, because, my lord, this useless formality is used routinely, my lord. The principles of natural justice won't be. So, my lord, I'll sum it up, my lord. These are the grounds. First, my lord, that the impugn order is issued in violation of the principles of natural justice. Second, my lord, promissory estoppel, my lord. Third, that the PPE is not a fresh settlement, rather it's an extension. Since the order itself says that the earlier order has been modified, and that power of extension is there with the age. And fourth, my lord, that the revenue aspect, the revenue was also taken care of, because the initial settlement, the revenue with which the fishery was initially settled was enhanced. And since, my lord, these these aspects ought to have been considered, there ought to have been an opportunity or a reasonable opportunity before passing the order of. These are the grounds, my lord, that's my. Yes. Huh? Outfit for.
13.5.
Yes, yes, yes.
13.5, 2020. 30, there is no 34. 13.5, 2024, yes. Ah. 366 of 2022. It doesn't want to address 366, that is not address.
Okay, I'll refer to that. WA what?
WH,
Is it is it WA 399?
no, 366. You either. No, it doesn't want to. Does- I hope so. Yes. 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 Ah. Because he was not settled with the. Correct, correct. No, there's on back, there's nothing. So that's yes. Ah. To tell exercise. Okay. That's all.
I'll just one clarification with regard to the party. 1 minute.
Yes, yes.
My lord, we take up 29.
29. Yes.
That is the initial settlement.
Yes.
My lord, 3 to Ramesh Chandra Das, Secretary, Pampara Fishery Cooperative Society. He's saying this time the PPP mode, it's settled with the society, but 2 points. Now, my lord would come to the PPP order, at page 30.
32.
30, second paragraph, my lord. Second paragraph,
Yes, yes.
third line, my lord.
Yes.
Stakeholder management, Arun Das, Dinobandhu Nayak as stakeholder management, and Arun Das, Messrs. Pampara Fishermen Cooperative. So it's the same society.
Huh? you engaging? What do you mean by engaging?
They know it is their order, my lord, AMPC's order. First of all, my lord should make a query, my lord, why this order was issued. Now, in the writ court, they cannot come and attack their own order.
No, no, but one thing is there. This Dinaja Bandhu Nayak, is he a member of this?
Yes, both of them, my lord, read the entire line. Engaging Sri Dinobandhu Nayak as stakeholder management and Sri Arun Das hyphen Messrs. Pampara Fishery.
Not hyphen, dashed.
Hyphen dash. So they both belong to the same society. I mean, initially it was settled also with the same society. Yes, they are not before the court because the stakeholder. How does it?
The society is not before the court.
So why the society will file a writ petition, madam? Because
Why
the
not?
stakeholder is Dinobandhu, he has to.
No, no, huh? No, no. it
Dinobandhu and the other person has to be. And my lord would come to my paragraph because it was settled and they belong
No,
to the same.
no. You have not said that they are a member of the.
Yes, I have said it, my lord.
No, where?
I have pleaded it. In paragraph 2 itself, my lord. The fourth line, in this regard, it is stated that it is answered. Page 9, paragraph.
Yeah.
Page 9, paragraph 2. Fourth line, fifth line, my lord. In this regard, it is stated that fishing operations of the said fishery are managed by the petitioner number 2 through
Page 9.
page 9 of the report.
Yeah.
Paragraph 2. In this regard, it is stated that the fishing operations in the said fishery are managed by the petitioner number 2 through Messrs. Pampara Fishermen Cooperative Society Limited, and the petitioner number 2 is also the secretary of the said cooperative.
How does it help this statement? No, but the settlement has been made with the juristic person, not with you individually.
These two.
Ah. Correct.
I'm saying it physically. Here the petitioner number 2, here the petitioner number 2 is the secretary.
Who's denying that?
I'm not saying the second order was by way of.
Okay. It appears that the society is not here.
Society is not here, but the petitioner number 2 is the secretary, man.
No, but you are filing it in an individual capacity, not as a. The society is the one who has been settled with the fishery, not the individual.
I know by way of the CPP mode, there is one stakeholder management. There is one stakeholder management and the other one is called. I've been admitting all that. When did I deny that, madam? He himself has submitted, madam, the PPP is not illegal in the judgment. I have shown it. So is it wrongly recorded?
But PPP mode has to be done through tender process.
Not the tender, but the procedure.
Let me.
Then paragraph Malo to be the last.
Yes, just a minute. Yes. Wait. It is categorically submitted. Para 38. Yes. Where are you reading?
Internal page 44 is referring to the judgment rendered by Honorable
Page 44, para 38. How does it start?
the learned standing.
Read it from there.
The rules have not yet been framed by the AFC. Assam Financial Rules. Assam Financial Rules 254 refers to PWD, my lord. What is it? I can show it, my lord, right away. Assam Financial Rules. Get it, get it. 254 Assam Financial Rules. If my lord checks the contents, my lord, it refers to PWD, tenders by PWD. You can set up-
No, this writ petition is for why was it filed this writ petition? What are the basis? Huh? No, this writ petition, this one. That is made his judgment. What was the basis for the writ petition? What was the grievance of the petitioner?
TP modes were cancelled.
TP modes were cancelled. And was this one cancelled?
My also, because, yes,
It was cancelled along with them. So if it cancelled, how is he before the court?
that is why that I submitted at the outset, my lord. More for you. My lord, just a minute. Just a minute.
Yes, yes, where is the name? But number one is them. Huh? So it has been, so they're challenging this order. Also they're challenging it.
The judgment what my lordship is referring to, our matter was also tagged with the bunch of it.
This. Ah.
But my matter and the other two matters were segregated because my initial appointment, initial settlement was by way of a tender, and all the other cases, all the other fisheries, the initial settlement itself was by way of a PPP, direct settlement. That is why I've raised the point that my initial settlement was by way of a tender.
So your case is that yours is not a direct settlement to PPP mode, but it is a
Extension.
extension of the earlier
Earlier
settlement
tender.
and it was extended by way of a PPP mode.
Yes,
That's no? Simple. So that's one. So we have to see whether that extension could have been done by way of to an PPP mode by not following the earlier normal method of extension. That's all.
In case of extension, the question of tender would not automatically not arise. Why would the question? It's an extension. And that power is there with him. So my lord can either decide on all the aspects or other in my humble submission. So my lord may remand the matter back, give me an opportunity, I'll let them give a, because after all, my lord has to take it into consideration that the PPP mode order was issued by them, approved by the chairman and the managing director. Thereafter, on the basis of their representation, I keep on.
So in this writ petition, the learned single judge, the coordinate bench, held that PPP mode could not be done without issuing a tender.
No, it was not held.
Huh?
The learned single judge did not go into that aspect.
What
The
is
learned single judge had held that since the initial settlement, PPP, it could not have been done directly because it's not an extension. That is why the rules of natural justice won't apply. In all the writ petitions, the petitioners have contended that we were not even given an opportunity to represent. Directly, it was cancelled. So,
direct?
my lord, his submission, paragraph 47.
Naturally, but where? You show me where it is beneficial to you.
My lord will see his submission, paragraph 47, page 49. It will be clear. Internal page 49, paragraph 47. Yes, 42.
Huh?
The issue which arises for determination in this series of cases is as to whether the action of AFDC in cancelling the settlement order in favor of petitioners relating to various fisheries is sustainable in law. However, to answer the said issue, it has to be first examined whether the initial settlement was done in accordance with. My initial settlement was done in accordance with. The answer to the preliminary issue regarding the validity of settlement made with the petitioner would also lead this court to take into consideration the various grounds urged by the petitioners, including the ground of violation of principles of natural justice before such cancellation. In other words, this court is also required to examine if the same yardstick with regard to the application of principles of natural justice can be applied in case of initial order of settlement is held to be in accordance with law, and if such settlement is held to be done illegal. The court had decided thereafter, in cases where the initial settlement is illegal, there is no requirement of natural justice, and hence, my lords, paragraphs starting from 57 to 62, 63, 62, where the cases relating to useless formality have been discussed. And thereafter, the court has come to a finding that no principles of natural justice are not required because the initial settlement was illegal. It would no difference would be made, my lord, even if the petitioners are granted.
No, anyway, I got it. I got it.
332 order refers that the earlier settlement is
So it basically what the court has said, the court bench has said, is that one aspect is the natural justice aspect, and one aspect is whether the distribution of the state largesse has been done by following a procedure recognized by law. And basically said that no procedure has been followed, and a procedure should be made. So the extension done to you, given to you by way of a PPP mode, what
Right.
procedure was followed? Is there a procedure for giving a PPP mode?
they had awarded, my lord.
That
Because it
awarded
was
by
a COVID situation, and my lord, page 32, again, my friend had submitted that it is not an extension. The
No, no,
order itself
It
says,
is an extension.
yes,
It
my lord,
will,
would
it,
extremely valid.
no, you see, it may be an extension.
Yes.
But it has been extended, but the settlement has been extended by way of a PPP mode.
Yes.
And where there is no procedure. Right. That is what is basically clarified.
So insofar as procedure, it's there, they have to come. Not, that cannot be expected from the petition. There was a valiant effort by my learned friend, my lord. He got all the 44 petitions dismissed. Me.
Judiciary is,
They give settlement themselves and they come and settle, cancel it. My lord. There's a change of administration, then again there'll be cancellation of petition. That's what happened, my lord. There was this cartelization, my lord, in the fisheries everywhere.
you have run the fishery for the last 9 years. Be happy.
I'm not sad. I'm very grateful for our
Yeah,
fishery.
9 years you have run the fishery. And in fact, you have been given the option of running it for another 7 more years. So that means 16 years you can run the fishery. Huh?
I'm not that lucky. Very grateful. Thank you. There's
What
one
makes
more.
it?
Similar fact.
They're all on the same issue.
Same.
Huh?
The
That's
first,
different person.
the first two cases, my lord, is the same petitioner.
No, 25 and the 20.
I'll clarify, my lord, just take 2 minutes. 26 and 27, my lord. 20,
No, 25 and
25
26.
and 26, same petitioners, my lord. Same
Same
petitioners,
Ah.
because there was a status quo order in item 25. Disrespecting that status quo order, again a tender was issued, and that is why 26 was filed, item number 2. So 25, 26, and insofar as 24 is concerned, my lord, same set of facts, but a different picture in it, and a different
And the date will be different.
date will be different.
So
My lord requires this can be segregated tomorrow, my lord will take it up.
I know we'll take it up separately. I think. Otherwise the facts will be confused. Huh? Yeah.
Everything is.
No, I want to know when is the date of settlement.
I'll address your lordship now. Promo code is it?
Is that in the case? Why, that is Manish's order or something? Okay. That is Manish's side. Okay, where is the impugned, where is
Here,
the
my lord, the
extension
order- Order of settlement is 26/10/16, settled for 7 years by way of a tender. Thereafter, my lords, the EPP mode or the extension, which I call it, my lord, is dated 25/02/2021. And the impugn order of cancellation is at page 41, which is dated 8/4/2020.
Okay. But, the problem with this bench is that we have got to keep it CVs, otherwise very difficult to dispose of. Huh? Okay, we have to do, I think, wait, let me give dictation in item 24 and 20, 25 and 26. Third, Mr. P. Mahanta, Learned Counsel for the petition.
Okay, kindly excuse me for a moment.
Okay, no problem. Also heard Mr. P. Sharma, Learned Counsel for the AFC. Both the writ petition have been disposed of by the common. That's been an order of mine as much as the subject matter in it pertains the same, pertains, the same in both the cases. The petition is also the same in both the cases. No, is it? The petitioners are the same in both the cases or not? Huh?
25 to 30.
They're the same for the. The petitioner has paid for setting aside the impugned revised tender notice number 4 of 2020 issued by the respondent number three. For that reason, has paid for setting aside and quashing the impugned order dated 15/12/2021. Huh? No, in WPC 2920, your first pay 15/12/2021. What is this 15/12/2021? Huh?
15 plus 2025.
What is this?
WPC
What is this
29.
document? What is this document? Huh? Okay, 15/12/2021. 15/12/2021. Passed by the respondent number. Anyone issued by the managing director, Assam Fisheries Development Corporation Limited, packet APDCL. Who is the respondent number? Six. Six. Huh? Followed by which? The settlement of 44 fisheries without writing paper. Have been, without have been settled. Correct. Now, page of the page 40. What about this? Impute order dated. No, cut that. The data that will be third. Huh. Is it 1512? It's not a no, but out here they've asked for 1512 in their prayer. What is this 1512? Madam? Huh? I know, no, it is here in the prayer point. The prayer is there for 1512. That should have been it for. Anyway, I'll go by the repetition. I paid for setting aside. The order dated 3/12/2021 marked by the issued by the engine. Huh?
Paragraph eight,
Paragraph
paragraph
eight.
page number 14 or
Yes.
Yes, sir. The 1512 was not given to us, but they have filed it, my lord, in their affidavit in opposition, my lord would file. That is,
You have made a prayer for
Yes.
1512.
yes, yes.
Yes. What is the?
I'll explain why, my lord. Lordship would come to the impugned order, my lord. First one. Page, page, uh, page 37, my lord, 8/4/2022. Correct? Page 37. Here, my lord, there is a reference to 1512. I'll read it, my lord. A list of bills under AFDC comprising of different districts of Assam, which were settled without inviting tender under different modes and having no interim protection of the Honorable Guwahati High Court, are placed before me by the office superintendent to pass necessary order in connection with the earlier office order dated 15/12/2022. This was the first time when the list of bills, my lord, was disclosed. Now, my lord, would come to the affidavit in opposition filed by.
No, Mr. Counsel, when you have asked for setting aside an order, you should have that order in your writ petition.
I was not, I'll explain. I was not furnished with that order. My lord, to be clear, if my lord produces that order.
Just right, no, just right. Whatever I said, the petitioner has paid for setting aside. The order dated 15/12/2021 and 8/4 and the consequential order dated 8/4/2022. Passed by. It's a consequential order, I think.
Yes, consequential. So this is the order, my lord,
Okay,
there.
right. He has also paid for, petitioners have also paid for setting aside the tender number 2 of 2020. And the revised, revised tender. Okay, the revised tender issued by, point number 3. Next one, the petitioner's case in brief is that pursuant to an NIT dated 7/7/2015 for settlement of the Borkana fishery, Borkana, Borkana fishery for 7 years, comma. A settlement order dated 28/8/2015 was issued by the respondent number 3, settling the Borkana fishery, Borkona fishery with the petitioner from the financial year 2015 to the financial year 2021, that 2020, that is till 31/3/2020. For a total consideration of rupees 94,71,000. Thereafter, an order was issued on 5/12/2020 by the respondent number 3, with the approval of the respondent number, with the approval of the chairman of the AFD, that is respondent number 2. Directing management of the Borkona fishery for a period of 4 years with effect from 1/4/2021. Where does it say PPP in page 32? In page 32, where does it say PPP? Out here, there's nothing PPP. Direct management. No, huh? What have I said? Directing, uh, directing management of the bid by engaging the petitioner number 1 as stakeholder management and Shri Arunda by way of direct management system. Where does it, what is direct management? There's no direct management.
It also says modify the previous settlement to their perspective.
What is the direct management system?
Direct management, manage a stakeholder management is there, and
direct management. Put up. Nothing is said out here about the PPP.
That is incorrect, madam. Here, stakeholder management and stakeholder management and the other, Shri Arun Das, both belong to the same Pampara society. It's there, madam. Let me kindly read it. It says Shri Dinobandhu Nayak as stakeholder management and Shri Arun Das, Messrs. Bampara Fishermen Cooperative Society. of
Shri Arun Das dash ML Bampara Fishermen Cooperative Society. Huh?
And also says that the previous settlement is modified. Which my lord will find the last but one paragraph. As the
Then
society,
where was it said that there was a PPP management?
it's not there here.
It's in the agreement.
Agreement. Yes.
So, sir. The order dated 5/3/2020 also stated that the management of the wheel may be extended for another 7 years, subject to satisfactory management of 4 years against the target value of rupees 14,88,300 per each. It was also stated that the arrangement made in the order dated 5/5/2020 was due to the norms and status of COVID-19 and financial crisis of AFDC Limited, not your financial crisis of AFDC Limited. So, sir,
Modification of that. Previous settlement was modified.
just before that, huh, you also right? Just before that. Where is that modification?
My lord, the paragraph starting with as the society, my lord has it. Last,
Just
last line.
after mentioning last line that target value of 14,88,300, no? Just after that. The order also stated that as the society had requested to merge the period of their settlement till the year 2021-2022 in direct management system for better management enhancement of the livelihood of the poor SC fishermen of the society, to compensate the loss incurred during COVID-19 and loss incurred by the society for the last year. They placed that the previous settlement order should be modified. Okay. Next. Thereafter, a deed of agreement for management of the Orkara fishery was made. No, the fishing fishery in PPP mode was made on one it was executed on 1/7/2021 between the petitioner number 1 hearing and the petitioner number 1 and the petitioner 1 and between the petitioners and the AFD.
To the society also.
Huh?
Also the society. Number
I'm not into that issue. I'm not very into that issue, whether it's a type of, how does it matter? Next. Subsequent to the above, then that, no, thereafter, by impugned order dated 15, now 8/4/22 issued by the respondent number 44 fisheries which had been settled under the PPP mode without inviting tender were cancelled. Huh? Yeah, that's all. Without, huh? Where, that's all. And also due to violation of section 24 of the Assam Financial Rules and the decision of the full bench of this court in MS 129 Arya Dablong Min Mahal Samabai Samati Limited versus Assam Fisheries Development Corporation Limited. What is the citation?
citation is
That's big one.
reported in manner 2001 2 GLR 333.
Reported in
2001 2 GLR 320.
2001 2 GLR triple. Huh? Next up. The petitioner being aggrieved by the impugned order dated 8/4 2022 passed by the respondent number. Put the same to hearing in WPC number 2920 of 20. Along with the tender notice that has been issued along with the tender notice number 02/2020 issued by the respondent number 3 for settlement of the fishery. This court passed an interim order of status quo dated 9/5/2020 in WPC 2920 of 2020. Subsequent to the above event, comma, the point number 3 issued a revised tender notice number 4 of 2020 for settlement of the same fishery. which was again put to challenge in the present proceeding. Yes. The same was also stated by this court. Huh?
I ordered it at 17/6/2022. There's still
Why, yes.
the acknowledgement are not final.
No, that's not, that's the same, that's the same as the same. This court, in its order dated 17/6/2020, directs the respondents not to finalize the tender. Pursuant to the revised tender. Next up. The petitioner's counsel has put to challenge. No, petitioner's counsel submits that the petitioner had made a challenge to the petitioner's counsel submits that the petitioner's challenge to the impugned order dated 8/4/2022 issued by the point number 6 has been tagged along with in which case was it tagged along?
Series of cases, my lord, judgment decided by legal justice making.
The only one is here.
No, of course, I did not take out with the law.
Actually, you did not take away.
I'll-
Actually, no need. Tagged along with a series of cases. Where the same impugned order has been put to challenge. That, so your case is not there among those lists.
No, it was there, it was
So
there,
there.
it was segregated. my lord.
So, however, the case was thereafter segregated from the other writ petition. Inasmuch as the petitioner's case was slightly different from the case of the other. According to him, according to, okay, from the other. Thus, though the learned, though the coordinate bench had disposed of the a bunch of writ petitions which had put to challenge the impugned order dated 8/4/2020. The same could not be made applicable to the petitioner. But how is it not made applicable? Your name is in that list also.
During the course of the hearing, it was submitted, like I submitted before the doctor, that my initial settlement, I'll explain, my lord. The other cases, my lord, there was no tender at all.
No,
Direct settlement in
no,
50.
one thing. This court, the coordinate bench has not set aside that impugned order. But your name is still there, so if it's not set aside, then what happens?
Individual,
But is not there.
there were different.
Whatever I said. Had dismissed the bunch of writs, we had dismissed, not disposed of, had dismissed the bunch of writ petitions which had put to challenge the impugned order dated 12. It has, the petitioner, it has been segregated from the bunch of that has been disposed of, the leading case being WPC number 2192/2020. Next up, the petition shall establish that the petitioner's settlement period for 7 years was due to end on 31/3/2020. However, due to the decision taken by the respondents number 2 and 3 for giving extension to the settlement period of the petitioners, for giving extension to the settlement of the fishery with the petitioner for a further period of 4 years under the PPP mode, comma. The it cannot be said, nothing. It cannot be said that the settlement of the fishery with the extension of the settlement, no, the extension of the fishery by way of settlement. No, the settlement of the fishery by way of extension on the basis of the order dated 5/12/2022 and the agreement dated 1/7/2022 was no meant not was meant that the when that no tender when that the petitioner had not been given the fishery by way of the by violating the rule. He submits that subsequent to the settlement, so he submits that the petitioner was also given the permission by the respondent number 3 by letter dated 28/1/2021 to dig additional to dig 4 ponds within the Borkanab fishery. And as the petitioner had incurred huge expenses for the development of the fishery, the petitioner, the petition, the respondents could not have cancelled the settlement of the fishery with the petition on PPP mode without issuance of a prior notice. They also submit that the doctrine of promissory estoppel is a factor in the case of the petition to submit. The PPP extension order not being a fresh settlement, comma, the action of the respondent in cancelling the settlement of the fishery has to be settled. He further submits that there was no loss of revenue incurred by the AFDC in extending the settlement of the fishery, as there was an enhancement of revenue payable by the petitioner for the extended period of the fishery. The petitioner also submits that notice has to be given to the petition prior to cancellation of the settlement of its fishery in terms of the judgment of the Supreme Court in the case of 2015 8 SEC 519. he submits that the doctrine of the promissory of profit is also attached to the case in hand, and in this respect he has relied upon the judgments of the Supreme Court in the case of AIR 1968 SC 718 bracket para 21 20 20 21 24 and in the case of 2007 SCC 529 bracket 19 to 25. That's all.
The coordinate bench judgment, the same interim order, different judgment.
With regard to
Same interim order, 512 order. Honorable Justice Barua and.
they said what?
Same interim order, they were.
There is a division bench order, there's no point. No point, there is division bench order. No. I can understand if there is something, but division bench order is going to cover it.
Division bench is not with regard to the order passed by Honorable Justice. You go to the case. My lord peruses Honorable Justice Barua's order, my lord. They have also, in that case also, it was remanded back for giving notice. And my lord would see the same interim order, 512, first one, 512. My lord has taken up Ranglal Mondal at page 3, my lord. Internal page. Case of the petitioner is that the managing director of AFPC had issued an order on 5/12/21, inter alia stating that all fields which were settled in any mode without inviting tender shall stand cancelled.
No, it is 8422. It is, yeah, the same impugned order, 8422.
Yes, same interim order, my lord. They've decided otherwise. That's what I'm saying.
Who?
The other three judgments.
The division bench has decided that 8422.
May I have a look? Well, I won't.
No, you can have a look later. Let me finish. Right. Look, I would have given you, but I would have put it, but there's no point. Anyway, right. Mr. P. Sharma, learned counsel for the AFDC, on the other hand, submit that while the settlement had been made, the settlement of the fishery had been made in the year 2000. 2000? 50. With but this has got no meaning, I think. We do not know. With one Ramesh Chandra Das, Secretary, Pampara Fishery Cooperative Society Limited. The present writ petitions have been filed by Sri Dina Bandhu Nayak, bracket stakeholder management, right, and Sri Arun Das, bracket stakeholder fishing operation. There is nothing to show that they are representing the Parampara Fishery Cooperative Society Limited, as the first title does not indicate that they are representing the said society. The affidavit of Sri Dinabandhu Nayak, petition number 1, also does not indicate that he is representing the society. Next. He further, the learned counsel for the AFDC further submits that the impugned order dated 8/4/22, which had cancelled the fishery settled under the PC2 mode. Correct. had been put to challenge in in a batch of writ petitions, the leading case being WPC 2192 of 2020, which was disposed of on 21/9/2020. In the said judgment and order dated 21/9/22, this court had held that now this court had had examined whether the settlement of the fishery under the PPP mode. PPP mode meaning what is the full form? Public-private partnership, like a PPP mode, had been done in accordance with law. This court had held that the general principles of distribution of state largesse have to be strictly adhered to, and settlement has to be preceded by a procedure recognized by law. It further held that the concept of PPP in settlement of fisheries is alien to the rules governing the field, and settlement can be given only by means of a tender process, strictly in accordance with the rules. He submits that as the subsequent settlement of the fishery in the year 2021 with the petitioner under the PPP mode had not been done in accordance with any rules of procedure. And as such, the judgment and order dated 21/9/22 passed in the batch of writ petitions covered the facts of the present. They also submit that the principles of promissory estoppel. And he also submits that the division bench of this court in WA number 366 in a batch of writ petitions, in a batch of writ appeals, the leading case being WA number 360 of 2020, had to decide as to whether the learned single judge in the batch of writ petitions WPC 2192/2020 has taken a correct decision with regard to whether an opportunity of hearing had to be provided to the persons who had been settled with the fisheries under the PPP mode prior to cancelling the fix. The division bench held that the same would be an futile exercise because they had failed out, because the appellants had failed to make out a case that the AFDC had rightly settled the fisheries in their favor. And as they were of the firm opinion that the settlement of the fisheries in their favor was illegal and void ab initio, they accordingly submit that no prior notice was required to be given to the petitioner in terms of the principles of national law. He also submits that he also submits that the extension of settlement of the fishery given to the petition is a fresh settlement. Is it under the PPP? Under the PPP. Huh? Does not say anything what? I have heard the net profit for the party. Huh? I have heard the net profit for the party. Uh, uh, okay, or three methods. Why am I? Oh, why am I? Okay, so I'm going to give it.
I think 24
Huh?
methods,
Huh.
24 carried together, or 24 methods.
I'll dispose it of the same issue.
Only the dates may be different methods because of the there already.
Show me. I want to see the record. Ah, yes. Huh? I'll take good care of it.
If that taken action against the MD but not the chairman who has approved the thing said.
MD, what has happened to him? He's suspended. And the DP is going on against him. Okay, just write that. Mr. P. Sharma also submit that the point number 3 has been suspended. Then the point number 3 has been suspended, and a departmental proceeding has been initiated against. Against whom?
Chairman is nothing.
It is like one lawyer friend of ours who has passed away sometime back. He used to say, you steal a little, they put you in jail. You steal a lot, they make you think. I don't know if it's true. I don't know. You steal a little, they put you in jail. Steal a lot, they make you king. I don't know if it's correct, but let's have a good laugh. Stop. Anyway, any other matter? Yes, sir.
Deeply of labor.
Item 15.
It is a retender,
Huh?
retender, by considering the earlier tender.
Yes.
Participant tender was there, where he was the third highest bidder. Particularly 1 and 2, they did not accept the tender. They become eligible. Instead of giving settlement to him, they go for a retender.
Question.
That is.
Yes, why?
Covered by this honorable Rajman Lordship. Basically covered Lordship.
No. Covered matter.
In,
No, tell me one thing.
Yes.
There was a reserve price?
no,
No reserve price.
no, I am also being a scheduled caste.
There is no reserve price or anything in the ticket. But in some times I said that is only for market, vegetable market. Yes, yes, so why are you not giving it? So this is a 60% or 40%?
So see, this is, okay, 40%, I think.
40% fee, but who is to settle the tender?
And the technical discussion, I'm talking of that.
Okay, so you take the decision, or did he take the decision, but someone has to take the decision. This is new.
Also, other
That's for how many years? How many years is this?
she's the first idea.
So sometime in there.
If we stay on there, but right, needed of the things, deadlock. So because of him, he being a, but she,
The order will continue.
she could get after 10 days.
Okay, right. Mr. P. Sharma, Planet Council for the response number one, Mr. S. Barwa, Planet Council for the response number two, four, and five. Are granted 10 days time to obtain instructions this time.
No, Lord, so why Lordship, the fishery will remain Lordship, so this because it's the ultimate loss of the government for the revenue, and the consumer is depriving to run the fishery, he being the eligible. Why Lordship this matter keep pending so?
We'll tell them to give you some more days because this is the matter on before 25th, 25th
Hello.
June.
But still then increase.
Interim order to continue till the next day.
Okay.
Yes. The senior late.
But my lord, I am here, my lord. I am waiting for them.
Uh, what is wrong with this order? What do you want? Sorry.
My lord, actually, earlier the order has been passed. So actually, final order has been passed. The appointing the arbiter.
Ah,
And already consent had already been taken by the arbiter from the arbitrator. They have already given consenting before the proposal. Now they have filed, again they have filed,
where is the order passed by this court?
my order is, order date is 10/4/24. Clause number 3, paragraph 3, Rana GP has referred to the document.
The problem is that the court has only held that inclined to, inclined to. He is not directly appointed.
That is, meaning that the court has appointed arbiter. Court did not allow their objection for not appointing them. Court has appointed us. And now they want to say that the, now they want to modify the order to the extent that the railway officer should be appointed.
They cannot.
To that effect, that cannot be done.
Yes, Supreme Court Supreme Court judgment reading this court says, give me the judge.
Your lordship has parted. Has been passed by your lordship.
I know, give me.
Yes.
We'll have to wait. What to do? Let's wait. Let's wait for the city. Because railways, there might be a different issue. Anyway,
Time being. Good, so I will.
yes, what is this? 36 more character losses instead of April 2023, it should be April 20. At page 9. Okay. Yes, it is. Right. Third, Mr. S.K. Das, learned counsel for the applicant, who submits that there is a typographical error in the sixth para of the order dated 21/3/2024, passed in WPC 375/2024. He submits that in the he submits that in the fifth line of para 6 of the set of the order dated 21/3/2024, the words April 2020, April, 2026, inverted comma, April 26 has been recorded. So, however, the same has to be April 2020. He accordingly submits that modification of the order may be made accordingly. Mr. D. Day appearing for the CGC. May appearing for the respondents number 2, 3, and 4. Submits that he has got no objection to the modification of the correction. No, no modification. Correction of the order due to typographical mistake. Accordingly, April 2024. No, according to the words April 2023, it will be replaced by the words April 2024 in paragraph 6 of the order dated 21/3/2024, passed in WPC number 375/2020. The application is accordingly allowed and disposed of. Right. There is no sir. After vacation. This is interim order that should be correct. Yes, madam. Yes. Right, list the matter after vacation. Interim order to continue this. No time. What is this item 22 about?
Process there is in challenge to an order of the industrial tribunal. Here is recommended by the people from the SN Sharma. Which is my
So what to do?
after vacation, so that at the time I may collect the.
Okay. List the matter out of the vacation. He's going to argue, she says he's ready. No. Yes, he comes. Is there a new judgment? Supreme Court or what? You want your own arbitrators. Is that allowed? Huh? From the railway officers. As per the arbitration clause. But then what about the judgments of the Supreme Court? So what do we do with the judgments of the Supreme Court? Huh? Sure. You've given it to me. I've given it back to you or not? Yes, it's
Section 12, section 5 also, railway cannot conduct their
Huh?
section 12,
Please,
section 5 also.
tell 5, no?
12. Not featuring any prior agreement to the contrary, any person whose relationship with the party of council for subsequent of
Not only that, the 7th schedule is also there.
7 schedule. So that can be
So, madam,
then judgment of the criminal court by. Your lordship is part of the judgment. I'm letting.
let her post. We'll listen on Tuesday. Okay. On the prayer of Miss Adrian. This is the matter. TEC, huh? This is the matter on that week. There is a subsequent judgment of mine on the same issue. Better one.
Another judgment is there. Another judgment.
There's another judgment after this.
Even
You give me that. That is more clear.
in another collateral branch is also decided in, justice Chaudhary also decided in same matter.